Good morning. Oh, I love that. I love that sound.
I'm not quite fan.
That's a definite sound. I want to call the meeting of the Dental Board of California to order. And I will ask Secretary Afriat to take the roll call and establish a quorum.
Good morning. President Morrow.
Present.
Judith Forsythe.
Here.
Steve Afriat is here. Fran Burton.
Here.
Timing is everything. Stephen Chan.
Here.
Welcome. Thank you. Yvette Ingram.
Yvette Chevalier here.
Thank you. Katie Dawson.
Here.
Kathleen King.
Here.
Ross Lodge.
Here.
Tom Lay.
Here.
Meredith McKenzie.
Here.
Tom Stewart.
Here.
Bruce Witcher.
Here.
Deborah Wu.
Here.
Mr. President, we have 15 members on quorum.
Thank you very much. At this point in time, we are going to go immediately into a closed session for the board. So I encourage those of you that are in attendance that are not authorized to be so in a closed session, that it is expected that the closed session will end sometime between 10:30 and 11. So it's going to be a long session. It's unlikely that we will reconvene as a full board before 10:30. I'm going to call the Dental Board of California meeting to order. Good morning and welcome to all of you. I want to ask you all, including board members and members of the public in attendance, to please turn your cell phones to silent mode and make sure that they are off of the table so that in case they vibrate, we don't get any noise feedback. You may notice that board members are accessing their laptops during this meeting. They are using the laptop solely to access the board meeting materials that are in electronic format. This meeting is being webcast and will be archived after the meeting and available on the board's website for viewing at a later date. This is an official meeting of the Dental Board of California. We have a designated time on the agenda for public comment and ask for public comment on each agenda item. Each person will be limited to 3 minutes per agenda item for comments. The board welcomes public comment on any item on the agenda, and it is the board's intent to ask for public comment prior to the board taking any action on any agenda item. If for some reason I forget to ask for public comment on an agenda item and you wish to speak on that item, please raise your hand, get my attention, and you will be recognized. I want to remind all speakers to please stay on topic and keep your comments to 3 minutes in length. Thank you very much for your cooperation. At this time, I would like to introduce a fellow dental board member from a northern state. Came down from Montana to cool off. Dr. Dale Chamberlain, if you would please stand, Dr. Chamberlain. Welcome to our meeting and welcome to California. Dr. Chamberlain also representing at this meeting the Western Regional Examining Board, and he will have some comments to make in the future. Before we start our meeting, I want to do my usual, and that is to read and remind the board members and the members of the public in attendance. Business and Professions Code Section 1601.2 states, protection of the public shall be the highest priority of the Dental Board of California in exercising its licensing, regulatory, and disciplinary functions. Whenever the protection of the public is inconsistent with other interests sought to be promoted, the protection of the public shall be paramount. And I think that's important that we all keep in mind. Okay? We have a very busy agenda for the next 2 days. We have a lot of work to do. we have a lot of important work to do. And at this point in time, I think it's important that we proceed with that business. And so, agenda item number 3, our Executive Officer, Karen Fisher, will handle that agenda item.
Before I get started, I'd like to notify the board members that on each side of the dais here, these are media outlets. So just to be aware, the cameras that are on either side of you are actually from media outlets that are taping the meeting in addition to our webcast. Also wanted to make note that we're hoping to break at 12:30 for lunch, and then we'll take it up again after the lunch period. So at this time, we will go to agenda item 3, which is essentially recognition of our new board member. Dr. Stephen Chan was appointed by the governor early part of October. His oath was signed October 12th, and today is his first meeting with the board. Welcome, Dr. Chan. Dr. Chan had the opportunity to come to Sacramento for a day, and I gave him the Dental Board for Dummies 101 course. We were together from about 10 in the morning to 4 in the afternoon, and I gave him a quick overview of what the board does. And as you know, you can't cover much in a day, and I think he was in a bit of a coma when he left, but he did come back today, and we're looking forward to your participation. His credentials are well outlined within the board packet. I'm not going to embarrass him by pointing out anything in particular, but you can go ahead and read what his credentials are. I'm sure you all have had an opportunity already to introduce yourselves, continue to do so, make him welcome and part of our family. At this point, Dr. Chan, if you had any comments you would like to make?
No comments.
Okay. Well, welcome.
And Dr. Chan, I want to add my welcome to you too. We've had an opportunity to meet and talk a couple of times, but I'm glad that you're with us, and we're looking forward to your future participation. Agenda item number 4 is the minutes from our previous board meeting for August 16. This has been provided to you in your minutes ahead of time for your reading and review. Would invite any comments or questions regarding or recommendations regarding revision of the minutes? Yes.
Page 6, last paragraph is Dr. George Marinon, not, just a spelling, not Marinoff. So I thought we should correct that.
Okay. So noted. Any other comments? Any other comments from the board members? Yes, Dr. Witcher.
Page 8, I believe it's Jeff Pogue, P-O-G-U-E, representing CSA.
Okay. So noted. Any other comments from the board? With that said, are there any comments from members and attendants of the public regarding the minutes?
Just a reminder to board members that you'll need to be speaking into the microphone. I think we did hear you, Dr. Stewart, but you can pull one of either ones that's either on either side of you. Please remember to speak into the microphone so that it will be picked up on the webcast and the people in the back of the room can also hear. Thank you.
Okay.
Someone needs to move.
Did anybody move?
Move to accept the minutes
Thank
As
you.
corrected?
as corrected.
That's correct. Do I have a second?
Second.
Second.
Who seconded that?
We had multiple, but Dr. Witcher was one.
And
We had a double one. Okay. All right. Call the question?
Dr. Morrow?
Yes.
Judith Forsyth?
Yes.
Afriet abstains. Fran Burton?
Yes.
Stephen Chan, I guess that's an abstention.
Yes.
Yvette Chappelle Ingram? Katie Dawson?
Yes.
Kathleen King?
Yes.
Ross Lai?
Yes.
Huang Lei?
Yes.
Meredith McKenzie?
Yes.
Tom Stewart,
Yes.
Bruce Witcher,
Yes.
Deborah Wu.
Yes.
Motion carries 12 with 2 abstentions.
Thank you very much. Also, a second part of this agenda item is approval of the minutes for the Thursday, October 13 board session. Those begin on the second set of minutes, beginning with page number 1 to number 3. This was a meeting held at the Department of Consumer Affairs headquarters office in Sacramento.
On page 2, Guy Atkinson's name is misspelled.
So noted. Any other comments?
Yeah,
Dr. Witcher?
on page 2 also is Dr. Michael Mashne's misspelled, as is Dr. Jeff Pogue.
Okay. So noted. Any other comments from the board? Okay, with that said, any comments from the members of the public in attendance? Yes, please step up to the table, identify yourself.
I'm Dr. Karen Seibert. I'm the president-elect of the California Society of Anesthesiologists. On page 3 of the October minutes, Dr. Pogue's actual statement was not that an anesthesiologist should be present in the room when administering general anesthesia, but that a separate qualified independent anesthesia provider should be present. That's different from an anesthesiologist.
Okay, thank you for your comment.
Thank you.
Any additional comments? I'll accept the motion for approval as revised.
So moved.
Second? It's moved and seconded. Call the question.
Stephen Morrow,
Yes.
Judith Forsythe,
Yes.
Afriette abstains, Fran Burton,
Yes.
Stephen Chan abstains, Yvette Chappelle Ingram.
Abstain.
Katie Dawson,
Yes.
Kathleen King.
Yes.
Did you want to be recorded as an abstention because you weren't there?
No, I don't technically have to, as
Okay.
long as I went through the minutes.
Ross Lai,
Yes.
Wang Lei,
Yes.
Meredith McKenzie,
I'll abstain.
Thomas Stewart,
Yes.
Bruce Witcher,
Yes.
Deborah Wu.
Yes.
It's 10 ayes and 4 abstentions. The motion carries.
Thank you very much. Moving on to agenda item number 5, our budget report. Sarah Wallace, our Assistant Executive Officer, will lead out in that report.
Good morning. My name is Sarah Wallace. I'm the Assistant Executive Officer for the board. Before you today is the first quarter budget report, reporting on the Dental Assisting Fund as well as the State Dentistry Fund. The board packet includes an expenditure summary of where we are as of September 30th of this year. The first quarter began July 1st and ended September 30th. We are on track. We're about 23 to 26% of our spending, so which is appropriate for the first quarter. As we've previously reported, we are on schedule to have a deficit in our fund in fiscal year 18-19. However, as a result of the fee increase that was approved this past year and it going through the final rulemaking phases, we are expected to be just fine. That is expected to go into effect on July 1st of 2017. As if everything goes as planned. I'd be happy to answer any questions you might have.
Do any members of the board have any questions regarding the budget report?
I did have a question, Sarah, about the expenditures for Breeze. And I would assume that that is under financial information system? state operations, is that?
Yes, and actually, we had a separate handout at a previous board meeting. I believe it was at the May meeting that broke out the Breeze expenses. The Breeze expenses as to date were in the process of being finalized, so I will have updated expenses to share at the next meeting.
Okay.
They're included as part of the expenditure and the funds, but they're not a separate document broken out, so you have a detail breakout of what the actual expenditures are.
Okay, any other comments or questions from members of the board? Okay, with that said, any comments or questions from members of the public in attendance regarding our budget report? Okay, with that said, we'll move on to agenda item number 7. No, I'm sorry, number 6. And Sarah Wallace again will lead us through that agenda item discussing our strategic plan.
Early this past summer, Karen Fisher and I met with the Solid team at the Department of Consumer Affairs, and they assigned a liaison to us that facilitated the board's strategic plan. And so in early August, we began with a survey that was sent out to stakeholders. Component societies received the survey. It was also posted on our board's website, where we received responses in relation to the board's SWOT analysis, outlining the board's strengths, weaknesses, opportunities, and threats. We additionally held focus group meetings with board staff, a separate focus group meeting with the board management, and then Karen Fisher was also interviewed. On October 13th and 14th, the board met in Sacramento, and a facilitated strategic planning session was held where we outlined all of the board's objectives and goals for this next 4 years. This strategic plan will begin in 2017 and is expected to last until 2020. As a result of that meeting, Solid went back and crafted the final report that you'll see in your board packets today. What we're asking for today is for the board's approval and adoption of the strategic plan to put into place. After this plan is adopted, board staff will meet with the Solid facilitator, and we will engage in action planning to outline the objectives and action steps that it'll take to achieve these goals over the next 4 years.
Thank you, Sarah. Any comments or questions from members of the board regarding our strategic plan? I would like to make the comment that of many strategic plan processes, developments that I've been involved in the last, 30 plus years, the strategic plan that was facilitated by members of the Department of Consumer Affairs staff office was, in my opinion, very, very professionally done. It was a collegial working group of board members and staff that were able to sit down in small groups around small tables and actually do a very, very productive discussion of what our goals are and what actions we plan on taking to accomplish those goals, and measurements through that process to establish how well we are in compliance with our process and our strategic plan. So I want to compliment all of the board members that were participating, and certainly give a public thanks to the Solid members and the staff of the Department of Consumer Affairs that facilitated that process. So with that said, are there any comments or questions from members of the public regarding the strategic plan that we have published in our agenda packet?
I'll make a comment
Yes.
if I may. I just wanted to say and echo your remarks, Steve and Dr. Morrow, in that not only was it a productive, constructive day, but those folks really made it fun. And so we had great conversation, and I think we moved our agenda forward in a very positive way. So I'm excited about what the future holds.
Thank you, Bruce. Thank you very much. Yes.
I just had one question specifically on the document, Goal 2, number 1.7. Talks about research the feasibility of implementing in-house stipulations, to expedite resolution, reduce costs, and safeguard. I'm assuming that means add personnel to do that directly, but I wanted just a little clarification. Sorry, it's goal 2, number 1.7 is going to be page 9.
I'm sorry, so what was your question
Yeah,
again?
I think I was just making sure I understood what that one was.
Okay, so-
I'm reading that to mean that that would be having personnel in your
Right.
department
It-
that would take care of this, rather than using, I think
This-
right now, right, we use the enforcement group?
It would
or-
mean that essentially the stipulations that I negotiate wouldn't necessarily go through the AG's office.
Oh, okay, okay. That's even a little different than what I thought, but thank you.
Okay, any other questions or comments? Okay.
Oh, sorry, I have one more. I had to look through my highlights.
Yes.
And this is just nitpicky. So on goal 3, number 1.12, it says continuously update dental school educational standards. I just wouldn't say continuously, because you're not going to ever do anything continuously. I would put more like regularly update dental school educational standards. It's probably more realistic.
Yeah, I appreciate your comment from continuously, but regularly would probably be maybe a better choice of words. However, the concept, I think, is that they certainly need to be updated on a regular basis, and it is an ongoing process. So we might do that as an ongoing update, but right, I agree with the choice of words. Any other comments or questions? Okay. All right, we're moving along. Any comments from the public regarding the strategic plan that has been published on our website and available for your review?
Mr. President, I move we adopt this with the one change of 1.12, that the word continuously be changed to regularly.
Second.
Okay, it's been moved and seconded that the strategic plan be approved with the modification of page number 10, goal number 3, 1.12, to change continuously to regularly. Okay, any comments regarding that motion? Any comments from the public in attendance regarding that motion? Secretary, please call the roll.
Stephen Morrow,
Yes.
Judith Forsythe,
Yes.
Afriet, aye. Fran Burton,
Aye.
Stephen Chan,
Aye.
Yvette Chappelle Ingram,
Aye.
Katie Dawson, Kathleen King,
Aye.
Ross Lai,
Yes.
Huang Lei,
Aye.
Meredith McKenzie,
Yes.
Thomas Stewart,
Yes.
Bruce Witcher,
Yes.
Deborah Wu.
Yes.
14 ayes, Mr. President.
Thank you very much. Okay, moving on to agenda item number 7, examinations. Our Executive Officer, Karen Fisher, will address that agenda item.
Thank you, Dr. Morrow. This is a brief update on the portfolio pathway to licensure. Board staff accompanied me and Dr. Stephen Casagrande, who actually now is operating as a former board member who was deeply involved in the portfolio pathway to licensure conception, implementation. He will now be working with us as a portfolio auditor. So he was available to go down with us to have meetings with Loma Linda University and Western University of Health Sciences. Both of them are beginning the process of bringing students into this pathway. Loma Linda has essentially started what they call a pilot, so there'll be a few students already who are going through it right now, but intend to July 1st ramp it up and bring more people in. Western University Health Sciences is gearing up essentially for starting this program July 1st of 2017. We received a number of compliments on the program. Everybody was very enthusiastic and offering suggestions on reporting requirements. When we started with this process, it was primarily, everything was on paper, and so the board will be, at a future examination meeting, we'll be asking the board to look at whether or not certain things could be essentially filed with us electronically. That will be something for discussion in the future. I know that our examination chair, Dr. Wu, will be attending future meetings, and we will be setting those up with the schools who have been implementing this pathway. UOP, UCSF are actively involved in this. UCLA and USC are coming along, but their numbers are smaller. So we'll be meeting with them to see whether there is anything we can do to increase participation. Currently, you see the statistics in the last paragraph in the agenda here. So we do have a number of portfolio applicants that have been licensed by this pathway. On top of this, we continue to receive inquiries from out of state, people who are interested in moving this concept forward. So we're enthusiastic about that also. That pretty much concludes my report, unless Dr. Morrow, you had something to add.
Yes. First of all, any of the board members that have any questions or comments? Yes.
Just curious, have we developed any communication tools, of FAQs, a manual to take into the dental schools and maybe leave with them? Is that something that we have in place and that we're using now? And I'd be happy to hear how effective that is.
So they have a, is this on? They have the binder and as well as our slides that are being presented at the schools, so they have that. And at our school, they're currently updating and calibrating faculty instructors as examiners regularly.
And that addresses many of the questions that are being asked?
It does, but there are still questions that come up because this is a relatively, new thing. So we're addressing them as we go along.
Just to add to what Dr. Wu stated, the schools have all been provided with copies of the candidate manual, which is, a guide for the students to follow. Also, a manual for the examiners, examiner training manual, to train the faculty to the dental board standards as far as assessment is concerned. And also PowerPoint programs for standardization and calibration of the assessment process. The manual for the trainers, the assessing trainers, have rubrics that identify the different criteria for assessment of the examination factors. So it's all calibrated, it's all standardized, and we have provided the schools with the necessary information for students and for faculty and for administrators of the school as to how to implement the process.
It is likely that in 2017, we'll be having meetings with the schools and could be actually putting a meeting of which all schools would be invited to participate and share their ideas. But at this point, we were planning to do one-on-ones, take that information, share it with the other schools. So we're ramping up. It's going to take some time, but the enthusiasm is still there, and we're hoping to build on that.
So
Yes.
I have a question regarding portability. I know that you mentioned that in the past meetings. Do you have an update on where the other
Sure.
states are?
Yes, I do have an update on that, and I was going to do that after board members had made the comments that they wanted to. So are there any other comments or questions regarding the portfolio examination process at this point? Report. Members of the public have any comments or questions? Okay. With that said, in the last year, I have been invited to and have given presentations to 3 groups around this country in different states. There is an organization, maybe some of you are familiar with it, some of you not. It is called the American Student Dental Association. This is an association of dental students in the currently 66 dental schools that are in the United States. Each dental school has their chapter of this association. And they have, 3 of those chapters have invited me to speak to them, plus also a dental board in Colorado that I met with personally, and the dental board in Iowa that we met with in a teleconference regarding the portfolio process. The Dental Student Association is very, very interested in promoting and furthering the concept of what is generically referred to as a curriculum integrated licensing examination. The California portfolio examination is, in essence, a curriculum integrated examination. That means that the student, during the course of their curriculum in their 3 to 4 years of dental education, will be able to, by choice, by option, to participate in this curriculum integrated examination, which will then afford them a license to practice dentistry upon graduation without any further examination. I'm sure you can understand that the dental students are quite interested in that process. To that end, I received last week a publication that is published by the American Student and Dental Association. It is called a white paper, Human Use of Subjects in Clinical Licensure Examination. This is written by the students, and it is a very interesting read. And to just very briefly abbreviate that is that they are asking for educational institutions, dental educational institutions, and licensing agencies, state dental boards, to work together to develop curriculum integrated format licensing examinations that are portable between states. Now, with the portability, the Colorado Dental Board has agreed to accept the results of the California portfolio examination for meeting their requirements for a clinical licensing, clinical examination for license in Colorado. Iowa is in the process of doing the same thing. In fact, and Kentucky has done the same thing. So Kentucky, Colorado flat out accept the results of the California portfolio examination for meeting the clinical examination requirements in their state. So there is some portability, and it is continuing to grow. I received just 2 days ago, when I was packing to come to this meeting, an email from one of the assistant deans at the University of Colorado in Denver. And her request was that they were wanting to accomplish the same thing that we have done here in California with the Colorado Dental Board, and was asking if we would be willing to work with them to help them facilitate that process, since we have been through it ourselves already. And I sent back an email to her stating that I appreciated her request, and that we definitely would be willing to work with her and would be in touch with the dental school in Colorado to see what we can do to help facilitate that. So there's some movement going on, okay? And obviously portability is an issue, because we move around a lot more now than we used to, okay? Deans of dental schools have a history of about 5 years, and they're gone to another school. It's unusual for a dean not to be in an educational institution for more than 5 years. Dentists are moving much more often than they are. Younger professionals are married to younger professionals, and they move around a lot. So we need to look at portability. It's a serious issue for licensing. Okay. Any other comments or questions? We'll move on. Okay.
So with that, does that mean that the licensed dentists through California portfolio can now apply for Colorado license?
That's correct. They can
Okay.
apply. No. Yes, Colorado accepts the results of the exam. Now, Colorado was in the process of trying to develop the same process with their
For
dental
the- for
board,
their school.
which again is what the American Student Dental Association is encouraging, the American Dental Association is encouraging, and the American Dental Education Association is encouraging.
Right. Well, I'm not encouraging our licensed dentists to go there after portfolio. I just want to get that information out
Right.
there
No, they
so
are-
that the students know. you know.
Their successfully completion of the California portfolio exam will meet the requirements in Colorado for licensure. Okay.
I think the board should be excited about the prospect of this idea moving forward. As you'll recall, it was many years in the making for us to do this in California, and that other people now that you wonder why things are timed the way they are. It looks like a lot of the country may be moving in this direction, which is very exciting. What I can see for the future of the board will be going and seeking statutory changes so that in the event that these states essentially accept our portfolio exam and adopt pretty much our model, that we would need to write in statute the ability for their people to come into California through that similar pathway. That's moving down the line. I don't know that we're there yet, but it is on the horizon, and it could get here more quickly than we anticipate.
Okay, thank you. Any comments or questions from members of the public regarding this agenda item? Okay. Thank you very much. Moving on to agenda item number 8A. We will have to reschedule this agenda item for tomorrow. So, just A. A will be tabled until tomorrow, okay? Okay.
Just as a little follow-up, A is being tabled till tomorrow because the board did not get finished with their closed session. So the board will reconvene closed session tomorrow morning, probably for about 2 hours. But we'll make that announcement toward the end of the day of when we think the public session will open up again tomorrow morning.
Okay. Moving on to agenda item 8B, dental licensure and permit statistics. And I believe that Sarah Wallace will address that.
Thank you. At the last meeting, there were several questions that came up relating to the data and some requests for additional data to be presented. And so I'd like to thank one of our newest analysts in our licensing unit, Jarrell. He worked tirelessly over the period of a month to try to pull the data together to ensure that we had accurate data for this licensing statistics, and we're hoping to utilize this as a template moving forward for also the dental assisting. As I was reviewing this, though, I did notice that there were some discrepancies from this data set compared to the data set that was shared at the August meeting. And after numerous validation attempts, we are fairly certain that this is the most accurate data that we have for our licensure statistics. We are now pulling our data from a new reporting system as a result of Breeze. So there's been some testing that we've been doing, and we have come across a couple of issues. I know at the last meeting there were 2 specific requests, one relating to the number of canceled licenses that would be canceled on a monthly basis. We're still fine-tuning that data, but what we have found is there's approximately 60 dental licenses that go into a canceled status monthly. And then a secondary question was why there was such a high number of delinquencies. And what we found as a result of doing additional research in the data was that, and we're still looking into this, but there are duplicates being pulled when we pull delinquent counts. So we're trying to fix that in our business reporting system to make sure that we're pulling accurate data there. So that may be contributing to why the delinquency number is so high. But what you'll also notice in here is we've now provided a breakout of the number of licensees per DDS in each county. We've notated the populations that have the highest populations per DDS and the lowest populations per DDS broken out by county, as well as an aging for the number of applications broken out by pathway that we receive on a monthly basis compared to those numbers that are approved, number of licenses that are issued, number of applications that are canceled or withdrawn or denied over the course of the year, as well as some very nice bar graphs to give you a visual. You'll see from the bar graphs that the summer months, June and July, tend to be the busiest months for the issuance and acceptance of applications. So if there's any questions, I'd be happy to answer, or if there's any additional information you'd like to see in future memos, I'd be happy to take that back as well.
Okay.
Sarah?
Yes, any questions?
I thought the county breakdown was really interesting, and I appreciate it. I know there's a lot of work to do that. Is there a way we can look at, and not for discussion here, but maybe down the line, how we might want to deal with underserved counties? There's a pretty large difference between some counties where, I won't even count Alpine where there's 0 dentists, but counties where maybe there's 1 for 5 or 6 or 7,000 population, and other counties where there's maybe 1 per 1,000 population, and how that affects care. I'd also be interested in learning, and if this is overwhelming, you can just tell me offline. And or ignore me. If some of these counties are served, but our statistics indicate where people are maybe domiciled. So maybe I'm a dentist in County A, but maybe once a week I'm going up to County B and I have a second practice there. So I'm a little concerned about underserved counties, and maybe we're taking a better look at that.
Okay, thank you, Steve. Any other comments or questions? Sarah, I have a question and maybe some clarification for members of the board as well as others in attendance. On page 2, at the top of the page, at the last item on that license, permit, certification, registration type, the last one are special permits. And I want to make sure that all of the board members understand what special permit licenses are. And number one, and secondly, are those special permits considered a California license? And are those 42 permits included in the the count of licensees in California? Because those special permits are presented to a faculty member at a dental school who does not, in California, who does not have a California license, but has a license to practice dentistry in some other state or some other country.
Correct. For statistical reporting purposes, the number of permits are not included in the total licensee population. The licensee populations that are reported on page 1 are just those that are licensed as a DDS in the state of California.
Okay. Appreciate it. Thank you. Any other comments or questions? Any comments or questions from members of the public in attendance regarding this report? Okay. Thank you very much, Sarah. Moving on to agenda item 8C. Okay, Dr. Witcher, are you going to give us that report?
Yeah, as
Thank you.
board liaison to that committee, I can give this report. The first item is discussion and possible action to accept committee recommendations for issuance of permits. We met on October 19th by teleconference to consider, actually, let me back up, also propose regulatory language and application of revisions. So under this, the staff presented regulatory language and a revised EFCS permit application to the committee for consideration. The committee approved this language and recommended the board initiate the rulemaking process at an upcoming meeting. That was item number 1. The second item is recommendation for issuance of permits to 2 applicants. 2 applications were considered, one from David Webb, DDS, and the committee recommended issuing a permit as specified here to Dr. Webb, consisting of Category 1 and Category 2, basically unlimited permit. And then the additional item was there was one applicant who, for unlimited privileges that did not meet the requirements, and so the committee made the recommendation to reject that application. So the first action that we are requesting is that we accept the report of the EFCS Credentialing Committee as specified. So could I have a motion for that?
I move that we accept the committee report, initiate the Rulemaking,
That item will come later, I'm sorry. It was a little, it
I
was a
thought
little.
this was the
yeah,
later board meeting.
Right, yeah.
Okay.
We've got another item.
Okay. We accept the committee recommendations and also approve the recommended licenses.
Second.
Okay, it's been moved and seconded. Any comments or discussion from the board? Okay. Any comments or questions from members of the public in attendance? Okay. With that not said, we call the question.
Stephen Morrow,
Yes.
Judith Forsythe,
Yes.
Afriet, aye. Fran Burton,
Aye.
Stephen Chan,
Aye.
Yvette Chappelle Ingram, Katie Dawson, Kathleen King, Ross Lai,
Yes.
Huang Lei,
Yes.
Meredith McKenzie,
Yes.
Thomas Stewart,
Yes.
Bruce Witcher,
Yes.
Deborah Wu.
Yes.
14 ayes.
Okay. Thank you very much. Okay, moving on to agenda item 8D, facial cosmetic surgery permit legislative report. And I think Dr. Witcher will
Yeah,
handle that.
I'll take that one as well, thanks. Basically, the board is required to submit a report pursuant to Business Profession Code 1638.1. There's a draft report attached for consideration and approval. And we request that the board approve the attached legislative report in order to submit this report to the legislature pursuant to BPC 1638.1.
Okay,
So
thank you
could I
very
have a
much.
motion for that item, please?
You can make the motion if you like.
Okay. Well, I move that board approve the attached legislative report in order to submit it to the legislature.
Okay,
Second.
thank you. Moved and seconded.
Kathleen.
Any further discussion?
have a
Any
question.
discussion from members of the public? Oh, I'm sorry. I didn't see any.
Sorry.
Yes, Fran.
At the top of page 4, where you talk about the committee recommending permit limitations if it's not satisfied, what would be the basis for not?
The applicant can apply for limited privileges if they have only demonstrated expertise through the use of operative reports or credentialing in certain areas, but not others.
So there are standards for each?
Yes, there are.
Okay.
It's based on what they apply for and whether their competency is verified through the process of
Okay.
application review and also operative report review.
Okay, thank you.
Just further information, since the inception, or since the implementation of this legislation, we have 29 permit holders. 27 of them are active, 2 have left the state. And most of them, and we have this on our website, it's available on our website and updated regularly. Most of the permits have been issued for both Category 1 and Category 2. Very few are limited, but there are a few. And this report essentially takes up from where we left off on the last report, so it's not cumulative.
Call the question?
Stephen Morrow,
Yes.
Judith Forsythe,
Yes.
Afriet votes aye. Fran Burton,
Aye.
Stephen Chan, Yes. Yvette Chappelle Ingram,
Aye.
Katie Dawson,
Yes.
Kathleen King,
Yes.
Ross Lai,
Yes.
Huang Lei,
Yes.
Meredith McKenzie,
Yes.
Thomas Stewart,
Yes.
Bruce Witcher,
Yes.
Deborah Wu.
Yes.
14 ayes.
Okay, thank you very much. Okay, moving on to agenda item number 8E, discussion and possible action regarding initiating the rulemaking process. And I think Dr. Witcher will take us through that as well.
Thank you.
Keeping
I'll
you
take
busy.
us through that as well. This item has been under development for a while. The Elective Facial Cosmetic Surgery Committee looked at many different ways of establishing regulations that would kind of improve the application process and set some standards. And this was their final recommendation that they made. There is some background material here regarding what was considered by the subcommittee in terms of developing the language. And the language is before you, as a regulatory proposal with some proposed language, which hopefully everybody's had a chance to review. If there's any questions about that, I'll go into that. But basically, the action that the committee is asking for is to accept the recommendation of the committee, approve the proposed regulatory language relative to the elective facial cosmetic surgery permit, initial application and renewal requirements, and direct staff to take all steps necessary to initiate the formal rulemaking process, including proposing the proposed language for 45-day public comment, setting the proposed language for a public hearing, and authorize the executive officer to make any non-substantive changes to the rulemaking package. If at the close of the 45-day period, comment period, and public regulatory hearing, no adverse comments are accepted, to authorize the executive officer to make any non-substantive rulemaking changes to the proposed regulations before completing the rulemaking process and adopt the proposed language, the California Code of Regulations, Title 16, Sections 1044.6, 44.7, and 1044.8, as noticed in the proposed text.
Very good.
What he said.
Is that your motion?
That is my motion.
That is my motion. That is his motion.
Second.
Okay. Could you repeat that motion?
So just a little further clarification. Since this legislation went into effect, we have had no regulations, okay? So this is the first thing you're doing by initiating this package. The second thing is that the application that was essentially, has been used to this point was straight out of statute, and oftentimes it was confusing. So it's been an interesting process. Had we really had people interested in applying for this, we probably might have brought this forward sooner, because it is confusing the way they're trying to negotiate through the statute as written. So we're hoping with the language and with the revised application that'll clear up a lot of things and just make the process more streamlined.
So we have a motion and a second. Any other comments or questions from the board members? Any comments or questions from members of the public in attendance? Okay, would you call the question, please?
Stephen Moore.
Yes.
Judith Forsythe.
Yes.
Catherine Fran Burton.
Yes.
Stephen Chan.
Yes.
Yvette Chappelle Ingram.
Aye.
Katie Dawson. Kathleen King.
Aye.
Ross Lott.
Yes.
Juan Lay.
Yes.
Meredith McKenzie.
Yes.
Thomas Stewart.
Yes.
Bruce Witcher.
Yes.
Deborah Wood.
Yes.
14 ayes.
Thank you very much.
Just a brief note for Dr. Chan, our new member. So what happens now is we put this out for public review, and the public will have 45 days to comment on any changes they would like. If any changes, if there are any comments received, staff will bring those back to a future board meeting, and the board will decide whether to accept or reject the comments. All comments made need to be responded to by the board, either in a rejection or an acceptance. If they accept the comments, it goes back out again for public review for 15 days, and so on and so on. So that's the regulatory process.
Understood. Thank you.
Okay?
Okay, moving on to agenda item 8F, discussion and possible action initiating the rulemaking process regarding licensure by Credential. Just since the subject came up previously regarding portability, as far as dental licenses are concerned, this is one of the ways which California, the dental board, and the legislature has facilitated or is facilitating portability, and that is that a dentist who has a license in another state that meets certain requirements by application will receive a license in California meeting those requirements without any additional examination other than law and ethics exam, which is traditional for every licensee in California. But I think we are in the process of initiating some revisions or additions to our rulemaking for that process, and I think Lucy is going to lead us through that. Okay?
Before you get started, Lucy, I just want to say that licensure by credential, we have no regulations.
Oh, we
So
have
this-
none. Okay.
We have none, and that's why it's critical that we start to move forward to discuss this issue. There are a lot of items that need to be reviewed and discussed, so we brought this forward in this format. It will be up to the board to see whether you actually need further discussion of the item before initiating. So there will be options. I didn't want you to think that staff is pushing to have you initiate today, but the discussion needs to start now and keep going because we really do need to get these regs on the books. But we may not, we may vet it further during this meeting. Lucy, it's all yours.
Lucy Sarkisian, Legislative and Regulatory Analyst for the Dental Board. As both Karen and Dr. Morrow stated, this has just been kind of an ongoing process that we've been working to develop language. During the last December meeting, we brought forth kind of questions we had, and today is kind of the draft presenting to the board of how the staff envisions, with all the discussions, the inputs that we've had of what the regulations we should look forward to. And if you look through, we've kind of changed some of the language in there, kind of defining what does otherwise restricted mean, and it's kind of giving you examples or parts. And then we decided that since there are two sections, one is for those who can apply through residency, they can use residency experience, and those who can use faculty experience also. And so we kind of have a section for those differences too within the program implementation. And so if the board would like to discuss or look further, we can definitely do that today, but at this time, staff is requesting that the board consider and possibly approve the proposed regulatory language relative to the licensure by credential application requirements and direct staff to take all necessary steps to initiate the formal rulemaking process, including the proposed language for a 45-day public comment, setting the proposed language for a public hearing, and authorizing the executive officer to make any non-substantive changes to the rulemaking package. If after the close of the 45-day public comment period and public regulatory hearing, no comments are received, authorize the executive officer to make any non-substantive changes to the proposed regulations before completing the rulemaking process and adopt the proposed amendments to California Code of Regulations, Title 16, Section 1028.6, as noticed in the proposed text.
Okay, thank you very much, Lucy. First, I just want to say that, and I'll take you in just a second, Dr. Witcher. This is a document that we just received right now. So obviously, we have not had a chance members of the board have not had a chance to read this. And unless we want to take a few minutes to read this and then discuss it, I think I will classify this as planting a seed. Okay, we're planting a seed today. We're not going to get a harvest from that plant yet, but we will get that harvest at a future meeting. So we need the opportunity to be able to read this, digest it to a certain extent, and come up with a reasonable discussion, questions and comments regarding it. So not expected to go into a discussion on this at this date, except that we are accepting these as the initial draft for regulations that are dealing with licensure by credential application. Okay, is that an understanding that we can go with? Okay, great.
Just
Yeah.
a follow-up question.
Yes.
How time sensitive is this? If this waits until the next meeting in terms of the process now that we have to move things through the rulemaking process?
We can, provided that this is new to all the board members today, we can definitely wait until the next board meeting to initiate the rulemaking process. So if time is needed to review, that's definitely an option.
Okay. I think in response to your question, Fran, and your concern, I don't think it's necessary for us to convene an emergency session to discuss it. I think it is an issue that we need to proceed with as soon as possible, but I don't think it's necessary to make it prior to our first meeting in 2017. Okay?
Dr. Morrow?
Yes.
I believe that board members received the language in their packets, but not the application.
The language was included in the electronic copy of the meeting materials that was posted on the board meeting website and provided to the board members. The applications are new, and they are an attachment on the full package on the back.
Okay.
Because the applications are considered part of the rulemaking file, they would need to be adopted as well as part of the approval.
So, because the initial language was available, is it the board's will to at least start a discussion today or hold off to another time? The packet that Sarah just passed out is the complete packet, which includes the cover memo, the language that's developed, and then the associated applications. So in the event that we carry this forward to a future meeting, hold on to this piece. We're trying to conserve, we're trying to go green. So hold on to this piece. This is the information that will be moving forward. But also wanted to mention, we had a subcommittee of Dr. Wu and Dr. Witcher who might be able to shed a little more light on some of these issues that are delineated here. So it's whatever the board's will is in terms of discussing this. We are going to be breaking for lunch at about 10 minutes. It can be something that you start to discuss, you come back to discuss, or you table for a future meeting. Those are some of the options.
I'm here at your service. What you want to do, we'll do. But again, we have about 10 minutes until we need to break for lunch, so. Yes.
Yeah, I'd just like to make a comment, and I'd like Dr. Wu to also weigh in on this. That we served on the subcommittee together. We took original concepts sent to us by staff that were items that they felt need to be addressed through regulatory change. In other words, some of the applications coming in, it wasn't really clear how they fit into our LBC process. This is all designed to clarify that for the applicants. And as you can see, it's very detailed because a lot of different states have very different licensing processes and issue different kinds of restricted licenses. And so this is an attempt to clarify this. I would just have to say that having spent, I'd forgotten how much time I'd spent on this, but going back and looking at it, I think the staff did a really good job of incorporating the subcommittee's suggestions and dealing with a lot of really difficult issues, like what do you do with somebody who's done a fellowship? How does that fit in? Is it a residency? Is it actual clinical practice? You know, there's a lot of these categories that this addresses, and I think it's quite thorough. I mean, I'm not saying it's done, but it's pretty close. And, you know, if people feel they need to spend some time on it, that certainly is in order. But I don't have too much more I can add from the subcommittee's perspective. I mean, I don't know how you feel, Dr. Wu, but
I'm in agreement with you. We spent quite a long time deciphering this, and I wanted to thank Lucy and her team. So unless the rest of the board needs more time to digest it, I don't know that I could clarify any more than what's here. So that's my feeling also.
I just have one question. On page 3, under program implementation, number 1, it says applicants shall submit to the board proof of at least 5,000 hours in 5 of the 7 consecutive years immediately preceding the date of his or her application. And then A, it says proof of completion shall be minimum 1,000 hours for each full 12-month period of licensure immediately preceding the date of application. So it sounds to me like if that's the case, then in 5 years preceding the date of submission of the application, that should be 5,000 hours. So why did we have to include the 7 years in there? Could you give me the explanation why?
That's language from statute, and so we were just trying to provide more clarification, just because what if someone provided us proof of doing, maybe in 2 years, 5,000 hours, and so what we wanted to do is kind of streamline that process to address that 7 years by kind of discussing, unless some kind of a qualifying event or circumstance arises that they can't complete it in 5 years, or they have that 7-year window. And so we are just trying to clarify by saying at least 1,000 hours would qualify about full-time employment, which is one of the requirements, part of the language. And so it's just addressing the statute language and kind of streamlining it so that our applicants better understand kind of the requirements.
Well, I'm just wondering whether or not it would be somewhat confusing. Let's say somebody who practiced full-time, say 4 years in a row, and then took off 2 years, and then practiced full-time the last year right before they submit the application. Will that qualify them for licensure by credential?
The way it is now.
By the
no, that
language
would
of
not.
It wouldn't, because,
It's not
but
consecutive.
there's 5,000 hours in the 5 consecutive years. So that means, so what if they worked 5 years in a row and then took off the last 2 years? And then they wouldn't qualify either, because they have to actually work 1 year. You see, I'm just trying to make sure that we don't have a gap in there,
But
so anyway.
these are exactly the questions that we're getting. We're getting all kinds of
Okay.
questions.
Okay, well, I just don't want to have that kind of gap, or some sort of confusion in there. Because it seems to me like A already pretty much says that you have to practice 5 consecutive years right before you apply. So if that's the case, why do we need the 7 years in there?
To address your question about if a dentist worked for 5 years and then took off 2 years and came back after that to work, after 2 years, well, the person would already qualify because he's met the 5 consecutive year requirement.
Then that's 7 years.
So they would,
However, the last 2 years, that person didn't work. And so according to A, that person must have worked.
Are you saying I thought you said that the dentist worked continuously for 5 years.
Right, in the 7 years preceding the
Okay.
application.
And they were consecutive years. So that person would qualify for licensure.
Okay, so
via
you're
the
saying that if a
credential
person
pathway.
worked 5 years full-time and then stopped working for 2 years,
Well,
That
if they
apply-
worked
that-
continuously for 5 years, that's all the statute requires. They would meet the 5,000 hour
Okay.
requirement.
okay. However, in A, it says, proof of completion shall be minimum 1,000 hours for the 12-month period immediately preceding the date of application. So that person stopped working 2 years before the application, that person would not be eligible, correct? Or am I, okay. Or am I lost? I'm sorry.
Yeah, I think A refers to a minimum.
You are correct. That's right.
And if they exceed that, then they come in under the 5 years. And the other thing is, the exception is if they have a qualifying event, which is described in an earlier section. And so if they stop out for a while for any of the reasons that are defined as a qualifying event, then they're okay. So, I mean, they really tried to think of, you can't think of everything, but they came close.
Yeah, well, like I said, I'm just giving, these different scenarios and how that would work to help the staff,
Well,
determine on eligibility.
I guess I'd like to go back and ask you if you have a question about the qualifying event definition, because that's where we tried to close that gap.
Yeah.
That's where really you should go then and ask us if a qualifying event that you're thinking of doesn't fulfill that definition.
Yeah, that's on
Yeah,
page
that's
2,
on page
6.
2.
So, yeah.
Well, I mean, it does say vacation time, so if I took 2 years sabbatical, would that qualify?
Yes.
Yeah.
As long as it's as described there, it has to be, as part of their employment agreement.
Yes.
So I'll go to the same one Hung was talking about here with, so people said it has to be 5 consecutive years. I didn't read it that way. I thought it's 7 consecutive years immediately preceding. If we're trying to say they have to have 5 consecutive years of work, I just think we need to slightly change the language here. So I don't know what the intent is.
Well, and obviously from this few minutes of discussion,
You now see what we went through.
I still am of the position that we need more time to digest this.
Apparently.
And we need to table this item for further discussion at a future meeting. Okay? And I was told by my friend sitting to my right that I was able to make that statement. So, and he will support me with his legal badge. Okay? So, thank you. This is important information. We need to get this vetted out because this is an area of concern for our staff and it's an area of concern for those applicants that are applying for this pathway as far as licensure. And if we want to be portable, you know, as far as going on record of inviting people to come to our state and practice dentistry, we need to understand it if we expect applicants to understand it. Okay? And if we're having trouble understanding what it means, then what about these people that are applying through that process?
And it may be just me who doesn't understand it.
I don't think so.
No, Dr. Lay, actually, this whole idea of 5 years, 5 consecutive years within the last 7 is very confusing. I mean, we can speculate why it came along to deal with people who have pregnancy or family illnesses so that they aren't completely excluded from it, but I think that this probably will take some time to get it right. Also, it was brought to our attention recently by stakeholders, some of the confusion with legislation that's introduced oftentimes doesn't take into consideration statute that already exists, and there are conflicts. Board staff is going to really be trying to look to the future to try to cover all the bases, essentially when laws are being developed. But a lot of these laws came in about the same time and oftentimes contradict each other. And so we want to try to work toward clarifying that. The LBC will be a huge step when we move that forward, and I think that this should be a priority that we need to keep the discussion moving and try and get it initiated as quickly as possible. Hopefully, we'll be able to do that at the first meeting next year in February.
Yes, Bruce.
Just one comment. When you're thinking about this, be sure to go back and become thoroughly familiar with the authorizing legislation, because the 5 out of 7 year is in statute. We can't really change that unless we go back. And I must say, when I read that, I found it very confusing too. So we did the best we could operating within the constraints of the statute. So there are some limitations on what we can do with the regulatory process.
Well, is that something that we could take care of in an omnibus bill? No? Okay. All right. Yes, Fran, you had a comment or question?
The answer to that question is no, omnibus, no.
Oh, okay.
You have managed to really confuse me. And so I'm going to put it like this. The 5 years are between, say, 2005 and 2012. The 7 years. And so it doesn't matter if you don't start in 2005 or 6, but if you start in 7 and get from 7 to 12, you have your 5 years.
No, I understand that part, yes.
Or conversely, you start in 5, but you finish, and then there are 2 extra years at the end. I think the key to this is to understand what the legislative intent was about the magic 7. And I think that will answer our question.
I agree.
And if you look at the legislative intent, I forgot which bill it was, but it does address the 5 consecutive years, that it must be done within the 5 consecutive years. So that's why the board even though it did not have regulations, they based it on the statute.
Yes. Yeah, no, I remember that because I was part of that recommendation. But, you know, it's just, the way it's written right now is confusing because it allows some gaps in there. So I just wanted to make sure that we address those. I'm not saying this is.
Well, another option is, once the board gets into discussing this language, if it becomes clear that perhaps that statutory language, 5 of 7 consecutive years, isn't working, then we go forward and see if we can get cleanup statutory language to clean it up. I mean, the statutory changes are all about what kind of background information do you bring to the table to show the legislatures that certain things need to be fixed. So that is a possibility moving into the future.
Good. We are now going to go into a recess for 45 minutes. That would be 1:15 after 1 for lunch. And Karen is going to explain to the board members how they can access.
So for the board members who've put in their lunch order, you now go across the atrium to the pub and pay, and they will then give you your lunch. Your lunch has your name on it. So if you head in that direction, then you go ahead and take the lunch and go ahead and have a seat within the atrium. It's a box lunch.
Okay, we'll see you in. I love that. We'll call the dental board meeting back to order. I hope you all had a chance to obtain some calories. And now we can get a little sleepy after those calories. So we are going back to start our afternoon session with agenda item 9, enforcement, 9A. And is Carlos in? Were these, well, I've already called it up. These are gonna be quick. Right, let's do it. Okay, thank you. Okay, Carlos.
Well, good afternoon.
Good afternoon.
Again, reiterate, if I had a good lunch here, try to go quick. Nobody falls asleep. Carlos Alvarez, Acting Enforcement Chief, and I'll be presenting the enforcement statistics and trends. With the statistics and trends, I have provided a chart as well, so everybody can refer to it, and it shows the previous 5 fiscal years and Q1 of the current fiscal year. So for a complaint compliance unit, complaints received, the total number of complaints received during the first quarter was 898, averaging 299 complaints per month. And currently, right now, the active caseload for the unit, it's 1,003. The average caseload per consumer service analyst during the first quarter was 201 complaint cases. Complaint aging, and that means complaint aging is that they have the cases that they're currently working. So for the first quarter, from 0 to 3 months, 459 cases, what equals out to 46%. 4 to 6 months, it's 319, which is 32%. And those 4 to 6 months is kind of a holding pattern where we're requesting records, we're waiting on complaints to return sign authorization. So during that period, 4 to 6 months is kind of a holding pattern, and that kind of shows the percentage of 32%. So 7 to 9 months is 163, which shows 16%. 10 to 12 months, 17 cases, which shows 2%, and 1 to 3 years shows 45 with a total of 4%. Cases closed. Total number of complaints, cases closed between July 1st, 2016 and September 30th of 2016. It was 640, averaging 213 per month. But the previous 5-year average was approximately about 203 closures per month. So with the investigations, we have a chart as well to refer. And so when I get into investigations, I want to talk about some of the numbers. Some of the numbers we're going to approve, and the reason being is because we had some openings down at our Orange office, and we were down 4 investigators. So currently, this month, we should be at 3 investigators. So we had one just start today at the Orange office, and that leaves 1 opening in the Orange. And so like I said, with that, with 3 investigators starting, these numbers are going to improve. So with the investigations, the current caseload, open caseload, there are currently approximately 855 open investigative cases, 273 probation cases, and 69 open inspection cases, and that's both north and south. So the average caseload per full-time investigator is 39. Average caseload per special investigator is 35, and average caseload per analyst is 36. So for the months, it's 0 to 3 months, it's open cases 36, which counts for 4%. 46 months, 53, which counts for 6%. 6 to 12 months is 172, which counts for 20%. 1 to 2 years, it's 418, which counts for 49%. 2 to 3 years is 153, which is 18%, and 3+ years is 23 cases, which equals 3%. Since our last report in June, the number of cases over 1 year old has increased from 61 to 70%, and the number of cases in the oldest category, 3 years and older, has increased from 6 to 23. And again, and that's because of the shortage that we had with investigators, but like I said, these numbers are going to improve. With the case closures, the total number of investigation cases closed with the Attorney General's office or filed with the District Attorney's office during the, it should be first quarter, and I apologize for that. It should be 253 with an average of 83 per month. So the average number of days an investigator took to complete the investigation was 353 days, and the previous 5-year average number of days to close the case was 378, so we have improved. And again, that's in our charts. So the cases referred for discipline. The total number of cases referred to the Attorney General's office during the first quarter was 27, so that equals out to approximately 9 referrals per month. And the 3-month average for a disciplinary case to be completed was 844 days. So with these charts, does anybody have any questions with referring to the charts?
I do.
Yes.
So I just have, it looks like, if you go to your first chart, which I need to go back to, it looks like the year 2015-16, the numbers of complaints, convictions, et cetera, was down 1/3 to 50%. But it doesn't look like we caught up on cases, completing cases, which I would expect if we had a quite a bit lower number last year, yet we didn't catch up. Do 3 investigators make that big a difference?
Actually, it was 4 investigators. It makes a big difference being short investigators. We had a total of 4 over in our Orange office, and then with our Northern office, we just got caught up, and I say approximately 2 months now, we hired our last investigator. So it does make a big difference with those numbers. And that's why I said these numbers are going to improve now with the hiring of the investigators.
Yeah, because it looks to me like last year might have been an anomaly in the complaints received, et cetera. You're heading back up again this year. And if you're short people at all, it's going to be a real issue because you don't have another low year.
Yeah.
To fall back on.
We're going to be able to catch up with the investigators because like I said, the average is about 39, but that average is going to go up. And like I said, we're going to be clearing out cases a lot faster.
Well, I want to thank you for this chart because I can get an idea what's going on. And until you told me there were investigators missing, I was pretty concerned about.
Yeah, and that's why in the beginning, like I said, it's going to improve. So if anybody has any questions on the charts, I could move on to the performance measures. Unfortunately, again, we don't have the performance measures for the first quarter, and that's because with DCA and with Breeze, They were experiencing issues, and they were fixing the first quarter performance measures calculations, and all because it falls down on new codes that they're creating. There's codes that they were deleting, so that's why they were unable to come up with these numbers. But these numbers will be posted on January 4th, 2017. So with the next meeting, we should have the first quarter performance measures to go over. And now with the diversion program reports and statistics. So the Diversion Evaluation Committee, DEC, program statistics for the first quarter ending September 30th, 2016. These statistics are derived from the Maximus monthly reports. So for intake referrals, for self-referrals, we had one in July, and August, September, we didn't have any. So enforcement referrals, we had one in August, and probation referrals, we had 2. And closed cases for August, we had 2, and 1 in September. So active participants right now, we have for July, we had 20. August, we have 23, and September, we have 21.
Thank you very much, Carlos. Any, do the board members have any questions or comments regarding these reports on enforcement? Okay, thank you. Any comments or questions from members of the public? Okay, appreciate your reports for us,
Thank you.
Carlos. Thank you very much. Okay. Okay, moving on to agenda item number 10, 10A. Discussion and possible action regarding the subcommittee's recommendations relating to pediatric anesthesia. I will turn this report over to board members Witcher and McKinsey for their presentation.
Okay, I'm going to start off. So as you all know, since the spring of earlier this year, the Pediatric Anesthesia Subcommittee of the Dental Board of California has been conducting a comparison of California's present laws, regulations, and policies to those of other states and dental associations, policies relating to pediatric anesthesia. We've also conducted a review of the relevant dental and medical literature and reviewed all the incident reports submitted to the board in compliance with the reporting requirements of the Business and Profession Code Section 1680Z related to pediatric sedation. In addition, the subcommittee received public comments regarding its pediatric sedation study at 3 separate meetings, which we held in July, August, and October. The subcommittee recognizes that few topics generate more controversy than the use of anesthesia, especially for children. And the challenge of reaching a consensus among interested parties on this issue is difficult. Although patient safety is always the foremost concern, the effects of regulatory change on healthcare can be fraught with unintended consequences. Any proposal should, therefore, strike a balance between established practice and evidence-based changes that provide greater patient safety. While the subcommittee concludes that California's present laws, regulations, and policies are sufficient to provide protection of pediatric patients during dental sedation, it recommends the following enhancements to current statute and regulations to provide an even greater level of public protection. And then we'll just step through them. We'll take them one at a time and discuss kind of each as we go. So the first one is that the board should continue to research the collection of high-quality pediatric dental sedation. We're going to continue to research the collection of high-quality data related to pediatric dental sedation and anesthesia to inform decision-making. Do we have any comments or questions from the board?
Oh, I thought you were going to go through each of them.
No, I think she's going to take each recommendation at a time. to discuss.
Each recommendation at a time.
Talk a little bit more about what that means.
Well, I can start, and then I'll hand it over to Dr. Witcher. So, as you know, there has been difficulty with the data that we have, and so I think we have talked over the last couple meetings about certainly it's beneficial to have additional data, So the recommendation is to see if there would be possibilities to get additional data or better data in the future.
If I could elaborate, as we know, AB 2235 requires expanded reporting parameters for the 1680Z reports. It also requires those reports to be filed in the event of any transfer to a hospital, not just within 24 hours. And so there will be a volume of data there that we will need to figure out how best to analyze and manage. The other thing is there was a section of that bill that recommended that voluntary reporting of near-miss type occurrences be encouraged and done. And we've examined some options as to how that might be done. As we know, there is no existing database that really lends itself to pediatric dental sedation reporting yet. There are a few out there that we're looking at, and we've had some discussions with some of the proponents of those. So that is the section that would remain, I think, under study. The other fact is that we would like to have some idea of the number of cases that are actually done in the state every year in different categories of sedation and anesthesia and by different permit holder categories. And so exactly how that is to be done, whether it's done at time of licensure renewal, for example, by just, tallying up on your electronic record-keeping system, how many cases you do and in what ages and some other parameters, we're looking at that. So
Okay.
the idea, that's the framework there.
And so what I would like to suggest, if there is going to be some cover that lays out the final recommendations, that we provide some specificity.
If I could refer you back to the preliminary recommendations, those included more detail under these sections.
Any other comments or questions from the board members regarding this recommendation? I would just like to add my comments regarding this number one recommendation. I'm totally in favor of this. I think that more and improved data set moving forward to inform us from a decision-making standpoint is very, very valuable. I believe that the data collection that we have been doing has been good, but I think better data collection will enable us to make better supported decisions moving forward. And I think this is extremely important. Not only is it important, but with 2235, it's mandated. So we don't really have a choice. This is a recommendation that we're required to do. I'm just simply saying that I agree with it. And we need to have a robust collection process to help us to make decisions. Okay, any other comments or questions? Okay, at this point in time, I want to open up for the public to make any comments or questions regarding this first recommendation. Please if you have any comments, please step up to the table and speak into the microphone so that we can all hear, and it'll also be recorded on our video.
Larry Trapp, I'm Loma Linda University here representing the California Society of Dentist Anesthesiologists. This particular area is of interest to me. I have testified previously that I would be happy to help to coordinate a program of development of what information is going to be involved. And I don't know the limitations the board's activities put on private parties, but one of our members was involved with extensive data establishment for the electronics industry. And I would like to see the board already starting this. Now with the new law, it's required. So it's not going to happen overnight. What we had before was an unspecified. That's the reason it was bad. It was just a name and whatever the individual chose to put into it. but it needs to be far more rigorous. And what's important is the design of the document has to allow retrospective analysis for identification of problem areas, problem individuals, and some solutions about how those things are handled. So I encourage the board to become proactive in the development of this.
Thank you very much for your comments.
Good afternoon. I'm Brianna Pittman with the California Dental Association. Also want to speak in support of this. And this is something that I know we've mentioned in other testimony previously. Really support better data collection and thank the board for being proactive in this. And I think as we've said before, we'd like to see if we can, one, look at finding the denominator of how many of these types of procedures are being done, and also looking at collecting data across professions so that we have some comparability of what's happening in medicine, nursing, and dentistry as well. Thank you.
Thank you very much. Any other comments or questions? Okay. Moving on to recommendation number 2.
Okay, so the second recommendation is the definitions of general anesthesia, conscious sedation, pediatric and adult oral sedation should be updated.
Okay. Any comments or questions from members of the board regarding this recommendation?
Bruce?
If I could just elaborate, again, this goes back to the preliminary recommendations where we laid out in detail that these would actually be the American Society of Anesthesiologists definitions of minimal, moderate, deep sedation, and general anesthesia that we would be looking to adopt into our current language.
Thank you.
So I have a question on that. What would be the steps and the timelines if we say we're going to go ahead with that?
Well, first we'd need, because the definitions are in statute, we'd first need to do statutory change.
That's
and then the regulations would need to be updated for consistency.
Okay. Any other comments or questions? Okay, with that, I will open it up to members of the public. If anyone has any comment or question regarding this recommendation, please step to the table and identify yourself by name and give us your comment or your question. Okay, we're all satisfied with this one, it sounds like. With that, moving on to
We'll go to item
number
3. We have 3 separate proposed changes to the sedation and anesthesia permit system. The first we have outlined under 3A, which would be a pediatric minimal sedation permit for patients under age 13. So this permit would replace the existing oral conscious sedation for minors permit. It would require education. To be eligible for this permit, the dentist must complete 24 hours of instruction in pediatric sedation plus 1 clinical case. This training must include airway management and patient rescue from moderate sedation. Item number 2, administration is limited to a single dose of a single sedative drug via the oral route plus nitrous oxide and oxygen that is unlikely to produce a state of unintended moderate sedation. And the third requirement would be a minimum of 1 staff member in addition to the dentist trained in the monitoring and resuscitation of pediatric patients must be present. Do we want to do these all individually as well, or?
I would say yes. At
Okay.
this point, I think it's important for us to take them a bite at a time.
Okay.
Okay, with that is,
We got Steve, yeah.
yes.
My question probably, it seems that it'll be throughout here, so I'll ask it this time for everything. The age 13, I've seen tiny, fragile 13-year-olds and some scary 13-year-olds. And I guess what I'm wondering is whether there was any discussion about body size relevance or anything as opposed to a hard and fast age. It would seem like there might be a 14-year-old where this would be an issue and a 12-year-old where it wouldn't. But maybe someone could shed some light on that.
Well, the age is based on what's in existing statute. That is the age by which we define the pediatric oral conscious sedation for minors permit. That same age is also roughly the same age as in the American Dental Association guidelines, where their educational and use of anesthesia and sedation guidelines cut off. They don't recommend below that age. Some states use other ages. I mean, an age is not maybe the best way to make the distinction, but that is customarily the way that it's done. And we didn't get into a discussion of whether you should use body mass index or nomograms or things like that actually would be more scientific. But everybody seemed comfortable with an age cutoff. There's been discussion of what that should be. This was what we proposed.
Thank you.
Fran?
Any other? Yes, Fran.
On number 2, the administration of is limited to a single dose of a single sedative drug by way of the oral route, plus nitrous oxide and oxygen. And then what? If that's not satisfactory, and then what?
If you have what occurs that's commonly known as a sedation failure, patient doesn't become sedated enough, you have to basically stop what you're doing and probably reschedule the patient and discuss other modalities.
And so while we are doing this, shouldn't we be that specific? Shouldn't we
Well-
also add that?
They wouldn't be licensed to do anything beyond that?
Yeah,
So that would be, this would be a limitation on their license, is that that's all they could do? So, I mean, they couldn't do anything else. Right.
The
So they
limitation
do
is that they have to meet the definition of minimal sedation.
Well, then I would suggest that we state it in a different way. In my opinion, this is not specific enough.
I'm not sure I still completely understand. So this is, these would be the limitations basically of the license, right? Or the requirement. So it has the educational requirement, it says what you're allowed to do under the license, just like the practice of
And
dentistry
maybe it's
allows
as
certain
simple
things.
as under this license category, you can only do, or this is just too general for me.
If I could elaborate, this is schematic language. When this goes to statute, there's a whole process by which that language will be developed. And I think that as long as the intent is clear, then that will be done during a subsequent process.
Okay.
And we can note your comment for the record that you
please.
wanted it more specific.
Right.
And add that as a comment and a direction.
And then in 3, the staff member who is trained in monitoring and resuscitation, do we want to add something on follow-up CE hours?
We did not address CE in this set of recommendations. That comes under a separate Business and Profession Code section, and we acknowledge that along with a number of other issues will require further development. However, there is a CE requirement for this category presently, so I would assume that if we're basically modifying the existing permit, that same CE requirement would stand unless people wanted to decrease it or increase it.
Yes.
Question, will the specificity of number 2 determine who is administering and how it's being measured?
What was the second part of that?
How it's being measured, whether it's out of the office or within the office?
Well, again, we're getting into details. This is designed to be a 20,000-foot view.
Okay.
You know, just broad picture. How are we going to divide up the categories? And there's a lot of detail which is available from other sources that can be added as this gets further development.
Okay.
Yeah, I want to emphasize that too. I think that it's important that we realize that our recommendations here are more conceptual than they are detailed, okay? Those details will obviously be worked out, and they will be worked out in the legislative and the regulatory processes as we move forward. So to try to dot every I and cross every T at this point is really not productive. We're looking at more conceptual changes that we want to report, I think. This is my philosophy. Okay, I'm not a part of this subcommittee. But I think what we're wanting to do is to report to the legislature, which is following Senator Hill's original request for us, and now it is supported by Assembly Bill 2235, and that is to give a report to the legislature regarding the results of our investigation and any recommendations that we have. But I think those recommendations at this point are more conceptual than they are detailed.
Just follow up to Dr. Chan's question about where the procedure is. These permits are typically related to procedures in dental offices. Is that what you meant?
Yes.
Okay.
Absolutely.
See, I got you.
Again, I could go into some detailed questions that I have too, but again, those I think would be better served to be worked out in the statutory and the regulatory process. Any other comments or questions from board members?
And just as a reminder, as we continue to go through the recommendations and the report, I think that the boards will come to the conclusion that this is the beginning of a topic that will be consistently addressed on a regular basis by the board. So we have a good comprehensive background document to put forward. We're discussing these recommendations at a high level. I suspect that in future board meetings, this discussion will continue to occur, and we'll be able to refine certain elements of this whole concept. This was limited in scope based on the time frame we had in which to report and answering essentially the mandate of what was required by Senator Hill's letter.
Okay, any other board comments or questions? Okay, I invite any comments or questions from a member of the public regarding this recommendation. And Dr. Trapp, you know the process. So.
Thank you. A short comment. I would suggest, based on your discussion that these are conceptual suggestions, that you put that in the subcommittee's final recommendations title.
Okay, first of all, I want to emphasize that that was my personal concept.
Okay.
Not that of the subcommittee or of the board, okay?
Well, I can make it separate from your comments.
Yeah, I want to make sure that's me. That's me saying what I think, not what the board thinks or what the subcommittee thinks.
Well, to be assured, from my perspective, that licentiates and permit holders, and by the way, we're using the wrong term earlier, the term is permit holders and not licentiates, which we were using earlier. But to make sure that they don't feel that these are written in stone and they have to abide by them, it would be better to put in the title subcommittee final recommendations, and somehow refer to that as being conceptual. And obviously that the legislature.
Well, if you're going to do that, you'd have to put Dr. Morrow's concept.
Because you want credit.
I don't want that. I don't want that.
So that was just a suggestion to make sure that nobody realizes that they're in stone.
I hope I clarified that it was my concept and not everybody else's. Okay, any other comments or questions from the public? Okay, with that said, moving on to moderate sedation.
Yes, so Part B would be a pediatric moderate sedation permit for patients under age 13. So this permit could either be a new pediatric permit or an endorsement on an existing moderate conscious sedation permit. So education, to be eligible for this permit, the dentist must have completed a Commission on Dental Accreditation, so CODA, accredited residency in pediatric dentistry or equivalent training in pediatric moderate sedation as determined by the board. The applicant must provide proof of completion of a sufficient number of cases to establish competency, both at time of initial application and at renewal. Part 2, administration of the drugs utilized is unlikely to produce an unintended state of deep sedation. And Part 3, personnel, the dentist and at least one member of the support staff must be trained in pediatric advanced life support and airway management, equivalent to the AAPD guidelines or as determined by the board. For children under age 7, 2 support staff, in addition to the dentist, must be present, and 1 staff member shall serve as a dedicated patient monitor.
So I have a question. So from the age of 18 to 13, there's just 1 member. And when you go, and when you go below 7 or below, you have 2 staff members helping the dentist.
You meant 8 to 13? I think you said 18 to 13.
Oh, I'm sorry, 8 to 13.
Okay.
And I'm just want to understand the logic there. And if under 7, 1 of the staff is dedicated to patient monitor, what happens if that child is 8 to 13? How does it work differently than it does for the 7 and under?
Well, the reasoning there we laid out at the last meeting on October 13th, where we identified under 7 or, the pre-cooperative age group of children that, they're going to probably require a deeper level of sedation. Some are manageable with moderate sedation, but not all. And so we identified that group as being at higher risk based on some of our outcomes that we reviewed. Some of the published studies, our own results, because we didn't really have any adverse outcomes over the age of 7 that were related to office sedation anyway. There were some local and some hospital cases. And that was also identified in previous reports, such as the Blue Ribbon Panel report. So that was the thinking there, is that maybe this group needed special consideration, and that was the subcommittee's recommendation as far as preliminary went and also in the final.
So for that 8 to 13-year-old, that 1 staff member would be doing patient monitoring as well as being trained in support of anything that might go wrong, right?
Well, usually the monitoring is a shared duty in moderate sedation between the dentist and the assistant.
Okay.
And the idea is, most of the guidelines recognize that 2 people are sufficient for moderate sedation, so that's why that's in there.
Okay.
I have a question.
Yes.
Is it, when you refer to support staff, is it your intention to have them defined in terms of their certification or abilities, or licensing or anything such as that, or could it be any 2 people?
Well, in a subsequent paragraph, you'll see that we identify the level of staff training and the description of that training needs further development.
Okay.
I mean, that we recognize, that's a whole subject in itself. Typically, assistants who assist with cases like this now do have some training that goes beyond what they learn in dental assisting. They have to, first of all, usually they have some experience working in a pediatric office or around small children. Second of all, they'll usually have completed some formal coursework, and there isn't necessarily a specific licensing category for that, except, we do have a sedation assistant category, which has not been heavily utilized, but it's there.
And I would imagine for the under 7 group where you have 2 people, that it's not only knowing how to monitor and deal with sedation, but also knowing how to rescue.
Well, that's the intent here.
Right.
And the AAPD guidelines, actually, the 2016 version has expanded language on the skills necessary that meet their guidelines, and they're actually quite well written. The other thing is they recommend taking a PALS course, Pediatric Advanced Life Support, which is an AHA course, which, is a pretty advanced course. And so I think, that would be kind of the minimum training, and then we would add to that.
Thank you very much.
Anybody else? Any other board member? I have a question and a comment, I guess, maybe more than that. From a personnel standpoint, we're stating that one member of the support staff must be trained in pediatric advanced life support and airway management. In referring to, in the term support staff, are you referring to staff to support the anesthesia or staff to support the dentistry that's being done?
Well, this is a term taken out of the AAP-AAPD guidelines, and because they're written as guidelines across procedural sedation, that is the term that is used. But they also, in the section under moderate sedation, describe that the staff person may assist with technical duties associated with the procedure being performed. And so it's fairly general, but it's kind of included.
So then this one staff member, support staff trained in pediatric advanced life support, could also be the dentistry assistant as well as the anesthesia monitoring.
Correct.
Okay. Then when we get down where at the bottom of this one, it says one staff member shall serve as a dedicated patient monitor, but it doesn't identify that monitor must be the one or should be the one that is trained in pediatric advanced life support. So basically you're saying one staff member shall serve as a dedicated patient monitor. You're not identifying the training or the skills or the abilities of that monitor. And my comment would be, I would like to see that in the under 7, that the most highly trained and skilled individual of the support team would be the one assigned to monitor the patient's airway and vital signs. The way it's worded here, it could be anybody. It doesn't even have to be the one trained in pediatric advanced life support.
Well, we could easily add on the language, trained in advanced, pediatric life support and airway management, to follow the dedicated patient monitor, and just add that phrase in there. And consistent with, we could just take the language from the one and just make sure it applies to the person who is that dedicated monitor. And I would, that would be, I don't see any problem with that.
Any other questions or comments? Okay. Members of the public, do you have any questions or comments regarding this recommendation? Welcome.
Yes, thank you, Dr. Moore, and members of the board.
Could you speak right into the microphone? Thank you.
I'm Dr. Mark Sikowski, and I'm president of the California Society of Anesthesiologists. CSA represents nearly 4,000 physician anesthesiologists dedicated to the safe administration and monitoring of sedation and anesthesia. We appreciate being able to participate in this process. Just to be clear, for moderate sedation, as defined by the ASA, means that the patient must respond purposefully to verbal and light tactile stimulation, and that this by itself does not require a qualified anesthesia provider as defined by CMS. However, for younger children who are always considered pre-cooperative, and for those who are unable to cooperate for developmental reasons, moderate sedation may not be adequate. What any proceduralist or surgeon seeks is a motionless patient, and for young children, reaching the point of non-movement to stimulus is by definition general anesthesia. Please note that even for deep sedation requires purposeful response, which again may not be achieved in this subset of younger patients. As common sense would imply, and according to ASA and CMS interpretation, you cannot delegate to an individual who is not themselves qualified to administer and monitor for that depth of sedation and anesthesia. Quote, may neither delegate nor supervise the administration or monitoring of deep sedation by individuals who are not themselves qualified and trained to administer deep sedation, and the recognition and rescue from general anesthesia. So even though we're talking about moderate sedation in the younger patient, we're saying that doesn't really exist, and it's really deep sedation / general anesthesia. We recommend the CMS definition of a qualified anesthesia provider. In addition, the requirement for end-tidal CO2 monitoring is part of moderate sedation by ASA basic monitoring standards. As well, the American Dental Association recently adopted a policy requiring end-tidal carbon dioxide monitoring for moderate sedation. That's ADA House of Delegates Resolution 37H-2016 from October 2016. So we would suggest the dental board now require this type of monitoring for all pediatric and adult patients receiving moderate or deep sedation. And the technology has improved where they have the nasal cannula that will sample from both the nose and the mouth to improve the accuracy.
And I'm Dr. Karen Seibert.
Excuse me just a second.
If the president allows it, may I ask you a question as a follow-up to your testimony?
Yes, go ahead.
Thank you. So children that are going through moderate sedation, who need to be responsive, what if it's not an issue of their age, but an issue of the environment they're in, and it's a little scary, maybe very scary, and there's people with masks and goggles, and they're just not able to respond to questions and things? Has your association given some thought to that, or should there be a familiar and safe adult in the room with them? Would that be something we should be thinking about?
May I answer that?
Yeah. Oh, yeah, if you're the better person.
Hi, I'm Dr. Karen Seibert. I'm the president-elect of the California Society of Anesthesiologists. And I think that the real point that we are making in this 3B subset is that we do not think that the single operator anesthesia model, no matter how you configure it, is safe for pre-cooperative or uncooperative children. And I would agree with you very much that that is not necessarily a predictable situation. And that would be the point of our strong recommendation that there be a qualified, separate, independent anesthesia provider for moderate sedation in pre-cooperative children or children of a developmentally delayed age or known behavioral problems, ASA 3 or 4, obesity, sleep apnea, other risk factors that make the whole provision of moderate sedation questionable at best and potentially very risky.
Thank you. And just a quick follow-up. What about my question about whether in those circumstances there should be a safe adult in the room, a familiar adult?
I don't think we can speak to that. I think that that's a separate issue from the safety of anesthesia.
Okay, thank you. And I know I cut off your testimony.
That's okay. That's basically what I was going to say.
Okay, now you can say what you were going to say.
And I would also say, as a mother, that I think every parent in this room knows that there's an inherent difference in taking a 3-year-old for a haircut and a 12-year-old for a haircut. And that the sedation that you give to pre-cooperative and uncooperative children is, as Dr. Witcher said, heavier because they require behavioral sedation, not just anxiolysis and pain relief.
Okay, thank you. Any other comments or questions from public members? A second, let me see if I have another one.
What is the topic area we're covering now?
3B.
3B3, right. Bruce, I'm sorry.
I just want to make a clarification. Capnography, the use of capnography for moderate sedation is a subcommittee recommendation. It comes in a subsequent section under number 4.
Bruce, did you have any thoughts about the question I asked about that familiar adult in the room?
You know, that's sort of an individual practice decision.
Sort of a clinical judgment.
Some people do it, some people don't. I think I would be reluctant to make that as, I mean, again, I think, again, we're trying to think conceptually here.
No, I appreciate that.
You know, to paraphrase Dr. Trapp's comment, that might be a detail that needs to be addressed somewhere. And I think there is some language in the AAPD guidelines that actually speaks to that a little bit. But it's a valid consideration, and, you know, I can understand the need for that.
Thank you.
Just my comment in response to that, Steve, would be that's pretty much a clinical judgment issue on the part of the providers, of the care providers. At that point in time, do we need to bring a familiar adult, a familiar face, a familiar person into this room to help the child to be calmed down? But that's a clinical judgment thing. It's hardly something that I think we should be mandating to do. Okay? Yes.
I'm Ariane.
Welcome.
Hi, how are you?
Good to see you again.
I'm Ariane Trelane, and I'm speaking as the Chief Dental Officer for a federally qualified health center. So while I totally appreciate and understand why we're here and what we want to prevent moving forward, I have concerns with these recommendations with respect to how it's going to affect the public health settings. The majority of our children that we see in sedate are 4 and under, and they have nowhere else to go. And putting in more regulations and asking for a 3-person operator in the clinics are going to affect the clinics. So I want to make that comment in terms of looking at it. I believe that we have practiced safely. Children's Hospital is also my dental clinic. So we have children that we sedate at the sites, and those children that need to go to the hospital, we take to the hospital. So I'm very concerned with that. And Mr. Afrat, to your comment, we have one parent with the child at all times, unless the parent doesn't want to be there because they get queasy. And so otherwise, the parent is there from when we give the medication, and they're the calming person, just to let you know. But I just think we need to be, whatever happens next, I would hope that you would also advocate for the state legislature to increase the reimbursements to our clinics so that we can afford to have this person in place. Otherwise, we're creating a barrier to care. Thank you.
Thank you. Any other comments or questions from the public on that subject, on this subject? Okay, Dr. Witcher.
Yeah, if I could just offer a point of clarification. We wrestled with this. I think speaking to a number of pediatric dentists and taking input from that community, although some pre-quadrant children definitely require deep sedation, no question, there is a subset that can be managed with moderate sedation. I mean, sometimes you have to have a papoose board, which is accepted treatment in pediatric dentistry, and I think Dr. Chan could speak to that. And so, you know, there's a lot of ways to get there. Sometimes the procedure is really not that stimulating to them, and so you don't need the deeper level of sedation. If you're doing oral surgery, you do. That's a different thing. But as far as, you know, some operative dentistry or cleaning teeth or something, and they just can't quite hold still enough to get the job done adequately, I think there's a place for this. And so it's going to be up to the judgment of the individual clinician, and if they find they're getting into that category where the patient just isn't adequately sedated with what qualifies as moderate, then, as I said, the strategy is to discontinue the procedure and go to an alternative method.
Thank you. Any other comments or questions before we proceed? Okay, moving forward.
So we'll go to Part C, the Pediatric General Anesthesia Permit for children under age 18. This permit could either be a new pediatric permit or an endorsement on an existing anesthesia permit. I said 13, didn't I? Oh, sorry, 13. I thought I said 13, so, okay, thank you. So the education, the dentist must have completed a CODA accredited or equivalent residency training program that provides competency in the administration of deep sedation, general anesthesia for children under age 13. So now I got 18 stuck in my head. So under age 13. For patients under age 7, the applicant must provide proof of completion of a sufficient number of cases to establish competency, both at time of initial application and at renewal. Personnel. The dentist and at least 2 support staff must be present. The dentist and at least 1 staff member must be trained in pediatric advanced life support and airway management, equivalent to the AAP/AAPD guidelines or as determined by the board. 1 staff member trained in patient monitoring shall be dedicated to that task. Item 3, when a dedicated anesthesia provider is utilized, in addition to the dentist,
Both the dentist and at least one staff member must be trained in pediatric advanced life support and airway management equivalent to the AAP, AAPD guidelines or as determined by the board.
Okay, thank you. We'll open up for comments or questions from the members of the board on this recommendation.
Question.
Yes.
And I have a feeling I'm just being dense here, but feel free to tell me that. It talks about patients, applicant must provide proof of completion of a sufficient number of cases to establish competency. How are they doing cases if they're applicants?
They would have completed those during their residency training program.
Thank you.
I have a question with regards to, and I think this is a big, thank you. I think that this is a big enough of an issue to ask at this time. I'm reading the recommendations, and, you know, I am concerned about children with disabilities, autism, other disabilities, some mental illness as well. Is this a part of, would this be a part of our recommendations as well? I know that that's I'm concerned about that, especially children with autism, because they respond differently. I heard that mentioned. In terms of our recommendation, do we fold that into our recommendations as well, or is this another issue? Is this another committee? Is this a part of another board? It's dental.
Through the chair. That has to do with your patient evaluation. And again, traditionally, we have not specified in law what particular risk categories are and how they should be managed, because some of those distinctions can be very difficult to make. In other words, you may have a high-functioning autistic patient who does really well just being treated like anybody else.
Right.
And then you have others that are completely unmanageable, that absolutely must be treated in some sort of outpatient facility that would be completely inappropriate for office treatment. And the same with, you know, the medically compromised small children, ASA 3s and 4s, you know, those are clearly not suitable for management in the office and other, you know, risk distinctions. But you have to rely on the judgment of the clinician to some extent. Now, you know, if, again, I think that would be something that maybe we could look at defining further in regulation. But again, we have to be a little careful because these are broad categories and how you define the distinctions. But certainly the need for treatment of developmentally disabled people, individuals, is, you know, something that I do. And so, you know, I'm very interested in protecting that, but also making sure it's safe, because there's a lot of special considerations that go into management of that type of patient.
Yes, well, I'm looking at it when we're talking about being proactive. And if we're talking about being proactive, then I think that that's something that we perhaps need to consider. I'm not talking about someone who has a 1 in a million type of disease or anything like that. I'm talking about autism is on the rise, mental illness, children, pediatric, under 13. And so I think that we can perhaps even be while we're being proactive now, we need to take that into consideration. I just want us to give it some thought.
That's a good comment, and I think it deserves to be addressed.
Okay. Yes, Kathleen?
So I want to make sure I do understand this after reading everything. So in this situation where it's general anesthesia, we're not requiring that there be a dentist and an anesthesiologist as two different people. They could be the same person still, right?
Well, again, the idea here is you have this concept of a team where you have 2 assistants, one who is dedicated as the patient monitor and who is trained to a higher level and capable of assisting in event of an emergency, in addition to the dentist who's trained in providing the anesthesia.
So it could be the dentist that does the anesthesia and the dental work at the same time, just like it is now, right?
Well, it would be the existing team model, which is not confined to dentistry. It also exists for other types of procedural sedation that are done in medicine. And I think that to say that the dentist is doing both is kind of mischaracterizing it a little bit because, it just depends on how you divide the duties. And clearly, if you have a dentist who has very minimal training in sedation or anesthesia, you will need a separate anesthesiologist. However, even in that case, we're advocating that the dentist be familiar enough that they can assist in the event of an emergency. And so basically, the idea is you have at least one qualified, trained anesthesia provider who may serve as a dentist in certain cases where the procedures are suitable for that. Or in other cases, you may need to have a separate anesthesia provider where the dentist doesn't have those training and qualifications.
And in some states, they do make it separate, right? They make it an anesthesiologist and a dentist in some states.
No,
Oh, I thought I read that in the.
no, that is not a distinction that is made
Okay.
in North America.
I didn't mean a distinction, but you would have to have both there for a child. I thought
Not
that was in-
necessarily. Again, I would be
No,
the
I know,
first
not
to.
necessarily, but I
Yeah.
thought I read that in other states.
No.
No?
And I'd be the first to tell you that this is another matter of clinical judgment. There are going to be cases where you really want to use a separate anesthesiologist, or maybe even go to the hospital.
Yes.
There are cases where the procedures are suitable. It's not for all cases in every situation by any means.
I have a follow-up to Kathleen's question. And thank you for your patience. You're putting up with all these questions from those of us that don't have the training. My question about the separate anesthesiologist is not about training, but about 4 hands versus 2 hands. That if something happens to go wrong, then only the dentist is licensed to administer or adjust the anesthesia, but they might have a bunch of tools in the child's mouth at that time. Is that an issue that we should be asking about or concerned about?
Well, a couple of things on that. First of all, you're going to need more hands in the event of an emergency. And second of all, in a true emergency, the rules are more or less suspended, and you're provided with authorization to do what you need to do to deal with the emergency. There is actually a specific section that addresses that. And so, there's a sequence for handling some sort of anesthetic-related emergency. It's detailed out in the office anesthesia manual in pretty good detail. And it addresses things like the sequence of what you do when something goes wrong. If an operation is in progress, what's the first thing you do? And it's remove materials from the mouth, that's number one, because you won't have access to the airway. Anyway, I don't want to get into too much detail here, but. Yeah.
Thank you.
Tom, did you have? No, I'm sorry. Any other board member? Okay, I have a comment that I would like to make. From my reading of the report, which will be following this, but also reading of the subject matter expert testimony, as well as guidelines that are published by different professional organizations for the administration of dealing with administration of sedation and anesthesia. And I think it's logical, it makes sense. It seems to me like that the younger the patient is and the deeper the level of sedation, the higher the risk. Okay. And I'm also hearing and seeing that one of the major risks is the inadvertent extension into the next deeper level of anesthesia. When you're dealing with general anesthesia, the extension to the deeper level is not good, okay? So with the younger the child, the deeper the anesthesia, the higher the safety needs to be to protect that patient and to also detect and put a stop to an inadvertent extension into the next level of sedation. And I'm not sure that, and my concern is that the personnel that we have identified in this situation are adequate to detect at a sufficient early sign and let the dentist know, who is trained to deal with that issue, that things are going south and we need to do something about it. So again, we're looking at under 7 and deep general anesthesia. I'm concerned that our recommendations at this point do not reflect the concerns that I have heard and read from subject matter experts and stakeholder organizations' guidelines to not only protect that patient, but to deal with inadvertent extension of the next level of sedation. Now, does that take a trained dental anesthesiologist or a medical anesthesiologist? No. We have nurse anesthetists that are certainly capable of doing that, and they understand we have in place statute and regulations that allows that to take place as long as the dentist who is delivering the care has the appropriate permit to supervise the nurse anesthetist to be that provider of the anesthesia. So again, I'm looking at a very narrow subset of the child, under 7, and the deepest level of anesthesia or sedation that we have a permit for. Are we adequately protecting that most highly risky situation and patient?
You want a response?
I love it.
Okay, a couple of things. One of the fundamental concepts that I think is fairly well accepted is that if you're providing sedation to a given level, be it moderate, deep, GA, not necessarily GA because that's the deepest level, you need to be able to rescue the patient from the next deepest level. That is your responsibility. And, you know, if you are not prepared to do that, you probably shouldn't be treating to the original level for which you are permitted. And that's in most of the guidelines, and that's kind of a concept which I think it's certainly in the ADA guidelines and a number of other guideline documents. As the staff training goes, you know, that is open for discussion. I've left that particularly as something that needs further development. It's like most things, when you have a trained, experienced team, they are familiar with the signs of deepening anesthesia, and they are involved in the monitoring process. And they are very adept at assisting with the management of those sort of situations. I mean, those things are trained during simulations, during drills, during courses. The protocols are in the office anesthesia manual. Even in, you know, and if you're doing small children, you have to assume that you're qualified. Now, I agree that we need some additional enhancements to protect the young age group, and that's why we've added a competency requirement, because we recognized not all of our anesthesia providers in dentistry are equally trained in that area. And so the idea is here to, you know, set a bar which they're going to have to meet. In terms of the number of cases, we've had numbers bandied around. You know, I think Colorado uses 10. I think that's on the low side, 10 per year. I think 1 a month is even on the low side. But it should be a number that, you know, that has some substance to it. And so I think that, again, any dentist is responsible to make sure his staff is adequately trained and adequately familiar with whatever procedure he is doing, from, you know, anything really under the Dental Practice Act. So I don't see that this is any different.
Appreciate your comment. I still am not comfortable with the level of protection that our recommendations at this point have in that youngest age category of patient and the deepest level of sedation that is permitted. And that's just my concern. At this point, I'm just stating it as a concern. From a standpoint of competency, I'm not aware of a Commission on Dental Accreditation advanced education program that includes sedation, whether it's moderate or general, that doesn't teach to competency and doesn't require in that competency process a specified number of cases that need to be done. So in completed a CODA approved, accredited or equivalent program that provides competency also provides an adequate number of cases to be done. So if we are going to, in regulations, set a number that we require for non-CODA trained permit holders, that we need to be consistent with what the commission sets as numerical requirements for competency, in addition to the fact that they graduated from a accredited program that taught to competency. Yes.
So you've said a couple of times that you're not comfortable with two support
I think you got
staff
my message.
and the dentist. What would you be comfortable with?
Right now, what I would be comfortable with is to go on record of recommending that in that lowest age category with that deepest level of sedation, that we have a dedicated general anesthesia, deep sedation general anesthesia permit holder to deliver the anesthesia and monitor the patient's vital signs, their airway, et cetera. Now, what that permit holder, who that individual is, would depend on their ability to qualify for the permit. So in other words, you have a permit holder, not identified as a dental anesthesiologist or a medical anesthesiologist, but somebody that's qualified to hold a permit at the same level of sedation that is being administered to the patient by the dentist, who would then be the dedicated anesthesiologist, in a general term, delivering the anesthesia and monitoring the patient in that youngest age, deepest level of sedation.
I'll respond, but I'd like to hear from some of the other board members.
Sure. Anybody else?
Well, it's just I'll take my personal experience. My son's had 8 procedures like this because he's been through chemo and radiation and has a special syndrome, and there has always been a dentist and an anesthesiologist. Always. I never even knew that you would do those two things together. So I have to say I agree. I also think the extra staff, is that the way it's written here, is there a training already set up that fits that category? Or would we have to develop a next level of training for that category?
Well, there are 2 training steps which are set up currently, and I can, elaborate on that. But that, it's
There's
subject
courses and all
Yes,
that.
yeah,
Okay.
there's a full curriculum and everything. It's underutilized at present due to difficulties with administering the program, but it's there, it's in statute, and the rules are done. But again, that's a broader discussion. As far as your personal experience go, I would submit that a child with your son's status would not be a candidate for office procedure,
Good
such as
point.
is suggested here.
Good point.
Yes, Dr. Stewart.
Steve, or Dr. Morrow, excuse me, I think you made an excellent
I'm
point.
Steve.
We're talking about patient safety here, but then again, I'm my friend Ariane Turley, Dr. Turley, when she talks about the potentially decreasing access to care because of the increased costs. We're up against, a couple of competing issues here, and I know we're all concerned about access to care and getting those patients good, quality, safe care. So how do we balance?
That's why we're here. That's why we've been chosen to be here at this time in this place, because we have the minds to think this through logically and responsibly. I agree with you completely that we are in a balance with access to care and patient safety. I had a number of reasons for reading 1601 at the beginning of this meeting. And if you recall, it said, if any other takes precedent over safety, safety is always first. Now, I appreciate access to care. I'm not throwing that out the window. But I'm saying when the oath that I took to become a member of this board said that I would uphold what's in this book. And what's in that book to me says, if I have to make a decision as to a very limited population of access to care versus safety, I'm going to do the safety. And you know what? Access to care will be worked out. We're talking about a small subset of people here that are the most vulnerable, and we are at the highest risk for what we're talking about here. And I trust that access to care will be achieved. Now, I'm an optimist. I agree with that. But there are ways of accomplishing what we need to accomplish. Fran?
Well, I'd like to.
Okay, I'm not going to addressing the anesthesia issue, but I can address the access to care issue. I've been at this for 31 years. It hasn't improved and it hasn't happened. So I'm glad that you're optimistic, and so am I.
Again, that's my optimism. Necessity gives birth to invention. And maybe it hasn't been necessary enough to manage access to care because it's been provided. So necessity, you don't know for sure what necessity is going to produce going down the road. But I do know that my main responsibility is protection of the public, and in this case, I'm focusing on those under 7 years of age children. Yes.
This is a tough weighing. What we're reminded of also for the access to care is a case that was called Diamante Driver, who couldn't get care and was, from what I remember of the case, couldn't afford the general anesthesia, and the baby died from a dental infection. So, and I can't believe I'm saying this, but in a bigger picture, we have to look at the bigger picture too. Under 3, yes, enhanced risk, absolutely. But I'm going to throw another monkey wrench into this too, because I don't have enough experience in knowing across the country what CODA accredited training actually does. There are variabilities around the country, in at least pediatric dentistry, on what type of anesthesia is presented, what types of cases they experience. So until we look at that, taking an assumption just because you've gone through a training program in pediatric dentistry, you are sufficiently trained, not only in administering, but getting out of trouble too.
I agree. At the present time, my understanding is that for pediatric dentistry residencies, CODA approved, teaches to competency in moderate sedation. In oral maxillofacial surgery and advanced education in general dentistry for dental anesthesiology teaches to competency in deep sedation and general anesthesia, both in oral surgery and in the anesthesia, dental anesthesia residencies. Those are the only 2 CODA advanced education programs that currently teach to competency in general anesthesia, deep sedation, general anesthesia. Periodontics does not, prosthodontics does not, and pediatrics is to moderate competency. Who's first? Fran is next, okay.
What is, for clinic providers, what is the average wait time to get in? for basic care? Either of you.
We need to focus back on our topic and our subject.
Well,
I think-
but I think it goes to your point about whether or not
Okay,
people
good.
are going to fall out of the sky to treat everybody who needs to be
Okay,
treated.
thank-
And I don't think that that's the case.
Well, maybe not now. Anyway, connected. I will give you the liberty. Go ahead.
Different everywhere.
So I've asked the question.
Okay.
Ariane Trelay, Chief Dental Officer for La Clínica de la Raza. Our current waiting time for Children's Hospital for the operating room is 9 months, and sedations are running probably close to the same for our in-clinic sedations. There is no one who's taking the Deni-Cal patients. So we only have the OR time that we're given at Children's Hospital. UCSF also is providing some care. As you may know, UCSF is will only take children, people who are on Deni-Cal. If they are children, they will not see adults on Deni-Cal. And so basically, it's up to whoever we can get at wherever we can get for that. It's a huge issue.
And the follow-up question is, what is the lowest level where someone would hold that dedicated anesthesia prevent? You talked about a nurse, that it could be a nurse earlier.
Nurse anesthetist. That's an advanced training beyond the nurse, a nurse anesthetist.
So it would be a nurse anesthetist
It
would
could
be the
I'm not
lowest
saying-
level?
Probably, yeah. I would
Okay.
say, at the present time.
Steve had a question.
Yeah, just, Bruce was inviting some comments. I walked in here thinking that my position would be that we should have a separate anesthesiologist. And I'm really struggling with whether that's the right thing to do or not. I am concerned, number one, as Dr. Morrow points out, that our primary responsibility is to the patient and patient safety. But I need to be convinced that that's necessary. If it's necessary, I become concerned that we're making a choice between perhaps depriving access of care to parts of our society who need it. And Dr. Lay, thank you for weighing in, because I was going to ask you to weigh in. And also, or making a choice that, well, this is the best way to do it, but we won't do it the best way for poor kids. And that seems, and I know no one's suggesting that, but in my head, I'm struggling with what's the right thing to do, and I certainly, I'm clear I need more information, and not ready to make those choices. What are the levels of people who can be certified? And as one of two people here, and my colleague, who's also a legislative appointee, has extraordinary abilities with the legislature, I'm sitting here thinking, well, gee, the speaker put me here. I probably ought to pick up the phone and call and say, you need to do something about this problem, because this is maybe a direction we're heading in. So I don't have any conclusiveness, but I just wanted to share my thinking that I'm hearing stories where two people in the room who have the ability to deal with anesthesia is better than one in some cases. And then I'm hearing maybe kids won't get care if we do that. So I'm just really struggling with it. I don't have a conclusion to my thinking, but I want to at least share where my head is at right now.
Thank you.
So let's add another piece to the equation. The access to care is not just for the poor, it's for the middle income too. When it becomes unaffordable, they'll decline to treat, which makes things worse in the conditions, which means going to the emergency room, which means hovering on life-threatening conditions for the middle income also. So it's not just the poor.
Anybody else waiting in line? Yes.
If no one has any other comments, I'll offer something, but maybe this will engender some more discussion. I mean, for me, it kind of comes down to looking at our outcomes. And we've had the opportunity now to review a lot of the cases, not all, but several, that have come before the board over the last 5 years due to various kinds of adverse outcomes from sedation. And I think we've had some insight into why that occurs and how it might be addressed. And we have, our numbers may not be perfect. We always want better data. That is never good enough. We all know. Anybody who's done a science experiment knows. But we do have some data. And it's accumulated over, I think, a fairly reasonable period of time, 7 years. And I can't tell you an exact number of how many cases are done, but California, with the size of the state and the number of sedation providers and people doing different things in a lot of different locations and settings and types of facilities, I think it's a pretty significant test of, the outcomes. And so I would just say that, consider that. You have the insight. You've viewed the details of some of these cases, most of which now are to some degree in the public domain, but still you've had, first shot at it. So think about that.
Any others? Should we open it up to the public now? Okay. At this point in time, I will open up to public members in attendance for any comments or questions regarding this recommendation 3C. I lost track of it. Thank you.
Hello, my name is Dr. Diana Belli.
By the way, forgive the interruption. We have 3 chairs, so if people want to speak, they can come up.
And be sure that you speak into the one of the microphones, please. Thank you.
My name is Dr. Diana Belli. I am a dentist anesthesiologist, and I provide general anesthesia to dental patients of all ages, both in the office and the ambulatory surgery center. I was trained in the dental anesthesiology program at Lutheran Medical Center in Brooklyn, New York. So I wanted to comment on 3C2, which is the personnel. In regard to any recommendations that permits any dentist to provide sedation in any level from moderate to deep to general to pediatric patients with only a course-trained assistant. The knowledge and skills required to administer anesthesia, monitor, resuscitate, and provide advanced airway management are only taught in advanced postdoctoral residencies over several years and cannot be taught in a dental or surgical assistant course or PALS certification. Therefore, any recommendations that state staff members trained in the monitoring and resuscitation of sedated patients does not sufficiently define the level of training required to perform these tasks. In addition, the requirements of residencies that define pediatrics as age 18 or under, residents could meet that requirement easily by treating only 17-year-olds, whatever the quota is. And a 17-year-old has the physiology of an adult. This does not sufficient training to be skilled and experienced in the administration of deep sedation or general anesthesia to patients 13 and under, especially patients 7 and under, because children under the age of 13 have a different physiology than adults do. The only postdoctoral residencies that require special and focused training and experience in providing deep sedation and general anesthesia to patients 13 and under are medical and dental anesthesiology residencies, which are of 3 years duration. So, my point is really that you cannot train the skills and the knowledge and the experience necessary to respond to airway complications, or any kind of complication that occurs under anesthesia in a weekend course. There's a reason why these training programs are several years long. And it's hands-on experience, 3 years solid of anesthesia in the operating room setting. So my question to everybody would be, to leave everybody with, would you want your anesthesia administration and monitoring to be performed by a sedation assistant with potentially a college degree or less who is not a medically trained professional? Or would you want your child's surgeon to be providing anesthesia and monitoring their vitals while he or she is also performing your child's tonsillectomy?
Thank you very much.
Good afternoon. My name is Jennifer, and I come to you today representing mothers and fathers, grandparents, aunts, and uncles, but most importantly, our children. I urge you to listen, and I hope we can work together to uphold stricter laws and policies when it comes to child sedation dentistry. It is our job to protect children, They deserve long and full lives. They cannot possibly protect themselves, so we must. We live in a day and age where we constantly hear of some kind of product recall, whether it be food, toys, car seats, the list goes on and on. These recalls are meant to protect our child from danger. I have heard countless stories and walked with families who thought they were doing the right thing for their child, who needed simple dental work, and were directed to child sedation dentistry. Some of these stories and cases turned out okay, and the child made it through the procedure with no complications. Others had minor complications, and some had major complications. And in some very unfortunate circumstances, children have lost their lives, all while having very rudimentary dental work done, maybe even unnecessary work. On top of that, we don't even know for sure all of the stories and data from what has actually occurred in these child sedation cases, because apparently there's no central data collection. I come here today to say the issue is in your hands. It is your responsibility to protect children in your care. They are coming to your dentist to be healed, not hurt. If one more child is injured or dies from child sedation dentistry, I hold this board 100% at fault for not acting quickly and responsibly on our concerns. I'm asking for the following to be implemented as quickly as possible. Number one, establish a system to determine that the procedure is completely necessary. Number two, once the procedure is deemed necessary, it is performed by both a fully licensed pediatric dentist and a separate, competent anesthesia provider. I ask that the standard of care of anesthesia in dentistry be the same that is expected in all other healthcare settings, so that consumers are not confused or misled as to the care of their child in these vulnerable states. And number three, develop a central data collection of accountability systems for all child sedation occurrences, which will report all complications, fatalities, and injuries. In closing, I would like to introduce Maggie, a perfectly healthy 4-year-old girl who needed a few small fillings done and was recommended for child sedation dentistry.
Excuse me, if you could conclude your remarks. You've gone beyond your 3 minutes, please.
Sure.
Thank you.
This is her minutes. This is her goofing off for the camera minutes before she sustained life-threatening injuries at the hand of your dentist. She was taken by ambulance to one hospital and later taken to another hospital in critical condition. And this is a picture of a little girl barely holding on to life with major heart and lung damage. Thank God she made an unexplainable, miraculous recovery and is alive today after a long 11 days of being in a coma. To this day, my daughter, Maggie's case has never been investigated by this board. It has been over 2 years, and I find this disgraceful and unacceptable. Some children were taken too soon, and many families are without their babies. I beg you to fight for my daughter Maggie and for every child that will be under the care of your dentist. Thank you for your time.
Thank you.
Dr. Mark Sagowski, CSA again. Thank you for your thoughtful comments of the board and other testifiers earlier. First, CSA supports one standard of care for deep sedation and general anesthesia, which means there must be a separate qualified anesthesia provider. CSA policy, Patient Safety Bill of Rights, adopted June 2016, supports one standard of care for deep sedation general anesthesia in any location, which includes a qualified anesthesia provider as defined by CMS for any patient of any age in any setting. The public reasonably expects and deserves this standard of care. Please note that a dental sedation assistant does not qualify to administer medications or monitor their effects for deep sedation, general anesthesia. To Dr. Wichiter, you made a comment earlier, which I'm not sure is 100% correct, but an RN, registered nurse, who has significantly more training than a dental sedation assistant is not allowed to administer or monitor deep sedation or general anesthesia. And third, I'd like to say, if it's illegal to do something as simple as texting and driving, why would you want to allow something as complex as operating and administering general anesthesia?
And this is Dr. Karen Seibert again, President-elect of the California Society of Anesthesiologists. I would like to respectfully point out to the board that if we as anesthesiologists are going to do a procedure under sedation, even moderate sedation, we are not allowed to supervise the sedation ourselves according to the medical model. We have to have a separate qualified anesthesia provider for any level of sedation that involves moderate, deep, or general anesthesia. And certainly for deep and general anesthesia, no surgeon is allowed to supervise a non-anesthesia provider. They cannot supervise an RN. They cannot supervise a medical assistant. It has to be a separate, qualified, licensed anesthesia provider. If your child's going to have a tonsillectomy, a hernia repair, if you're going to have a nerve block for treatment of pain, all these things require separate anesthesia providers. And it is our belief that the single operator anesthesia model is not safe for deep sedation and general anesthesia.
Thank you.
Thank you.
Members of the board, my name is Dr. Anna Kaplan. Thank you for the opportunity to speak to you again. And Dr. Morrow, thank you for your very thoughtful comments. As you know, I am here on behalf of my family who suffered an unimaginable loss. No one in my family or anyone I know will ever undergo anesthesia without a separate anesthesia provider again. We learned that lesson the worst possible way. So I'm here today to talk to you for every other parent who trusts the dental board to put patient safety as its highest priority. The most important question today is who will guard our children when they are the most vulnerable, rendered unconscious by anesthesia? Who will rescue them should they stop breathing? Who will monitor their breathing and quickly notice when something is not right? Will it be the same provider that's busy performing the operation, which is the status quo operator anesthetist model? Or will it be a separate anesthesia provider with years of experience, like an anesthesiologist or a certified registered nurse anesthetist? Or will it be someone less qualified, like a dental assistant? The established practice for administering deep sedation and general anesthesia to a child is to have a separate anesthesia provider that is separate from the surgeon. The practice that is in dentistry and oral surgery to operate and administer the anesthesia themselves is the exception. I have watched meeting after meeting of people coming up here and testifying, anesthesia experts, both medical and dental, testifying that a separate anesthesia provider is essential to prevent injuries and deaths. The consensus is clear among those with the most experience and training. However, these final recommendations don't specify who will be the qualified to monitor our children under dental anesthesia, allowing dentistry and oral surgeons to continue this dangerous practice and qualify a dental assistant as that monitor, that person that will be there. This is deeply disappointing. It strays far below the standard of anesthesia care in all other settings, and it ignores the recommendations put forth by the pediatricians and by the anesthesia experts. And unfortunately, it will result in more tragedies like the one my family had to experience. The dental community has a financial stake in this, in maintaining the status quo. Currently, some dentists and oral surgeons bill for both the operation and the anesthesia, and patients pay the ultimate price. Administering anesthesia is by far the most dangerous thing that a dentist and an oral surgeon does. Please revise your recommendations to ensure it's done safely. How many more healthy children have to die in a dental chair before you end the operator anesthetist model of care? Thank you so much.
Thank you.
Good afternoon. Thank you for allowing me to speak here today. My name is Paula Whiteman. I'm on the governing board of the American Academy of Pediatrics, California, and I'm the immediate past president for the American Academy of Pediatrics, California, Chapter 2. I'm speaking on behalf of the American Academy of Pediatrics, California, representing over 5,000 pediatricians. We have no financial stake in this cause. Our sole interest is in the health, welfare, and safety of the children of California. While a child may be in a dental chair for a short time, they and their family are our patient before, during, and after that procedure. If and when there is a bad outcome, we are still there caring for that child and there for the emotional needs of that family. The single operator anesthesia model is not an appropriate standard of care for our children. It is accepted nowhere in medicine, but exists in dentistry. Let me repeat, the single operator anesthesia model is accepted nowhere in medicine, but exists only in dentistry. There must be a second fully trained provider who is competent and experienced in anesthesia and airway management, as well as in direct patient care. To be clear, a dental assistant certified by an oral surgeon themselves is not adequate. Despite the fact that this is my 4th time in front of the California Dental Board, the committee has ignored our recommendations. The highest trained providers in anesthesia from both medicine and dentistry do not approve of the single operator anesthesia model. The AAP California will continue to monitor legislation on this topic and advocate on behalf of children, including educating both healthcare professionals and the public. Not one more child should suffer a potentially preventable death in a dental chair. Not one more. Thank you.
Thank you. Thank you.
You have a lot of talented people who have come up here, and the recommendations they've made are quite swaying to me as a person familiar with the medical and the oral surgery model as well. We have acknowledged in this committee and in front of the board that these young children are a higher risk patient population. They are indeed. We have also heard that the individuals who can administer anesthesia to them can do another procedure entirely at the same time of providing anesthesia. You won't see that in the hospital, as one of the board members suggested, because the hospitals don't give permission to do that in their institutions. And you might ask why that is. This is not not about who deserves to do what. Dr. Morrow, I thought, succinctly stated the issue in that it's about safety. And let me just, for the person who raised, and I don't remember who it was, the question, when I provide anesthesia, and we do provide to 4,000 patients a year, almost all of whom are on Medi-Cal at Loma Linda University. We have a 4 operating room surgical suite. And when patients come in there, if I'm treating them and I find information in the preoperative evaluation that means we can't treat them that day, we don't treat them that day. There is no question. How am I going to accept a mortality or an injury of a child because I wanted to finish the case? If they're in pain, we have alternatives. We can give antibiotics, we can give pain medications, and delay the treatment until such time that we get the information we need from the pediatrician or whatever the issue is. But we cannot risk a patient injury. Not in one case a patient injury because we want to get them treated. It just isn't an acceptable balance in this whole picture. I ask each of you, as I did on one previous occasion, what are you going to say to the next mother that has a deceased child of why you didn't give them the most competent provider of care that exists? I think that's a difficult question. I have told you before, I have never known how I was going to cope with a dead child. But it happens. So I implore you, as I have before, do not allow a child to be treated by the same person for anesthesia and whatever surgical treatment there is to be done. I don't want to deal with that, and I hope you don't. I know you don't. Thank you.
Thank you.
Hi, this is Dr. Diana Belli, again, dentist anesthesiologist. I wanted to, actually, I forgot to address the access to care issue that kind of came about after this discussion. And I just wanted to point out that there are a number of accredited surgery centers in the state of California who treat children, dental children dentally under general anesthesia all day long. And probably, I think I made an estimate at one point that through all the surgery centers that I know of, and through the fact that I have worked in a number of these surgery centers the first few years I was out of my residency, I myself did 3,000 children under general anesthesia for dentistry. In those surgery centers, there's always a separate dentist and always a separate anesthesiologist. And many of these children get great care in these surgery centers. So I think that, really to take a look at the numbers, of the 15 surgery centers that I know of, and of the ones that I know that operate 2 rooms a day, some operate 1 room a day. Usually, many of them will do, in many cases, I did 10 to 12 patients a day. So in doing a moderate calculation, at one point, I think I came up with 20,000 children a year. So it's not that that the implementation of general anesthesia in dentistry for children is an inhibitor of access to care, because many children do get treated. The second thing I wanted to point out was I noticed that in all of these discussions, there's been so much back and forth about definitions and practice models, and whether there's 2 people or 3 people or one person who's a sedation assistant and another person who's a dentist. I think the real question is, regardless of however you define the models, in the case where there is not a separate qualified anesthesia provider and a separate general practitioner, there's only one person responsible for the anesthesia ultimately, and it's going to be the dental practitioner. In the case where there is a separate qualified anesthesia provider and a separate practitioner, then the anesthesia provider is the responsible person for the anesthesia, and the dentist does not have to be responsible. So maybe the question we need to ask is, how many people need to be responsible? Thank you.
Thank you.
Good afternoon. I'm Dr. Alan Felsenfeld, and I'm an oral and maxillofacial surgeon and a professor at UCLA, and I'm certainly involved in training residents in anesthesia. But I'm here today representing the California Dental Association and its approximately 25,000 member dentists, many of whom use or provide anesthesia. I want to thank the Dental Board for the work the subcommittee has done. I was here at the last meeting as well, and it has been an extensive review. We understand that, and you have some tremendous recommendations concerning pediatric sedation and anesthesia in the dental office. Heard a lot of testimony from a lot of people who have slightly varying opinions. But as we've mentioned in the previous testimony, the CDA has convened a work group of providers and utilizers of dental sedation all of our dental community, many of whom are in the room today and some of whom have already spoken today. And over the course of time, we've looked at the best practices, some of the concerns that have been voiced today, and what we can do together as dentists, all of us together as one group, to ensure that children have access to care and that anesthesia is provided safely and effectively. Some people are saying there's no risk going to the hospital. That's not true. There is risk of anesthetic deaths and injury, no matter what the level of anesthesia is. We want to minimize that. We are fortunate that the numbers that we have today are not very high, and hopefully they will never get higher, but they will never go to zero. We all understand that. Everybody back here understands that. Again, we appreciate the work of the board. While each of the respective specialties may be affected in different ways by the details, and we may have additional feedback in the future, as this report moves forward through the legislative process, we look forward to continuing to work on this as a group. We will continue to convene and look at this. And we want to ensure that children have access to the safe and effective dental care that they need and deserve. We believe that this subcommittee report serves as a very strong framework and fulfills Senator Hill's requirements that you come up with recommendations that are to be considered and that will be helpful to the legislators in understanding what anesthesia is about. We look forward to continuing to work with you on this as well. Thank you.
Thank you.
Good afternoon. My name is Leonard Tycho. I'm a licensed physician, dentist, board-certified oral and maxillofacial surgeon, and I'm president of the California Association of Oral and Maxillofacial Surgeons. I appreciate this complex issue that you all are grappling with and don't envy your position. But the way I see the data, the way my organization sees the data, is it's actually strongly supportive of the oral and maxillofacial team model. You've had a lot of people come up here from medicine and discuss how it's different and therefore inferior. But if you look at the rates, again, if we take a bigger picture of this and look at over the past 6 years, there has been one anesthetic death. But, according to our best estimates, that's been in the past 6 years, roughly 1 million anesthetics delivered to pediatric patients. So that's a rate of 1 in 1 million. And I think that's comparable to any model within dentistry or within medicine. The opponents of the model keep saying, well, 1 is not good enough, 2 is better. So where do we stop? Do we add a 3rd or a 4th provider? Again, that's ridiculous to think about. I think the bottom line is just looking at the data. Going forward, collecting better data is always important. But as we stand now, looking to make decisions that's going to impact all of California's children, looking at the data now with respect to the oral maxillofacial team model, it's a very safe model. And we don't believe that it deserves any major changes.
Thank you for your opinion. Okay, do we have any more comments from the members of the public in attendance?
Good afternoon. I'm Karen Schneider. I'm Maggie's grandmother. Just quickly, obviously the data is wrong because my granddaughter is you missed my granddaughter, and that's really important to me, and I don't know how many others have been missed. So consider that there's things going on out there. Maggie lived, and maybe that's why you don't know about it, but she went out on a stretcher and was in critical condition. She almost died. They thought she was dying. They called us all there to pray over her. So she shouldn't have been there. So think about that. And as they say on Facebook, all lives matter.
Thank you. Okay. Well, I think we've reached recommendation number 4.
Okay, number 4, is requirements for records and equipment should be updated and include the use of capnography for moderate sedation.
Okay. Any comments or questions from members of the board regarding recommendation number 4?
Question?
Yes.
What is capnography?
That's a device that measures exhaled carbon dioxide and gives you a waveform readout on a monitor. And so it's both a quantitative and qualitative measurement of respiration.
Thank you.
Any other questions or
I
comments?
have a question,
From
too.
members of the board, yes.
I think I read this, but I'm not sure. Are dental offices required to have defibrillators for children? I thought I read it.
Any general anesthesia provider is required to have a defibrillator on site.
Okay, that's what I thought I read. Thank you.
Any other comments or questions from the board? Okay, I will open it up to members of the public. Any comments or questions regarding recommendation number 4?
Good afternoon. Nick Kaplanis, President, California Society of Periodontists. Just to make sure that we are specific, I would suggest an addition to that statement in order to read requirements for records and equipment should be updated and include the use of capnography for moderate sedation in children.
Thank you. Yes.
Mark Sikowski, CSA.
A little closer to the mic. There you
Mark
go.
Sikowski, California Society of Anesthesiologists. As
Thank
I
you.
mentioned before, the American Society of Anesthesiologists standard for basic monitoring for moderate sedation includes capnography or end-tidal carbon dioxide measurement for all ages, as well as the recent American Dental Association guideline. Thank you.
Thank you. Any other comments or questions? Somebody over here? Yes.
Again, on this one, this item was a little bit more fully developed in the preliminary recommendations, where we talked about some of the additional updating for records and equipment requirements. But again, we felt that that had been addressed. There were not a lot of comments on it, except there was some pro and con related to capnography, which we support.
Okay, thank you. Any other? Okay.
Okay, number 5, the dental board should be provided with additional authority to strengthen the on-site inspection and evaluation program.
Could I elaborate on that a little bit? Again, there were some specific recommendations made under the preliminary recommendations related to that. And it had to do with the fact that some of the permit holders who fail a second evaluation, we don't have a way of ordering remedial education. And so we wanted the authority to do that. In addition, we wanted greater flexibility in the assignment of evaluators under specified circumstances.
And I'm expecting that those issues will be more specifically identified as we work through the process. Yeah, thank you. Any others? Okay.
Okay, so I'll just kind of continue a little bit. We actually already talked about some of this. We acknowledge that the study addresses primarily pediatric sedation and anesthesia. And so that's kind of what our recommendations were limited to, and we specifically limited to under age 13, since that's the definition of pediatric in California. So I think there had been some questions about that. We also sort of addressed this earlier, that we recognize that specific requirements for staff training, continuing education requirements, the future status of existing programs, and the number of cases required establishing competency will require additional development. So this kind of goes to the discussion we were talking about earlier. This doesn't have all the details, and so I think everyone acknowledges that. So then finally, I think we had one additional statement that we recognize that the manpower and economic considerations for pediatric dental sedation are beyond the scope of the present report. These considerations will be critical to the successful implementation of any changes to dental sedation laws. We therefore recommend that there be an analysis of the effects of any proposed new legislation or regulation on access to care for pediatric dental patients prior to the implementation of any changes. Factors such as whether the costs of sedation and anesthesia are reasonable depends on how cost effectiveness is defined and calculated and on the perspective taken. For example, clinicians often view cost implications differently than would payers or society at large. There needs to be consideration of the resource constraints of the healthcare system, for example, Denti-Cal versus private insurance. Feasibility issues must be considered, including the time, skills, staff, and equipment necessary for the provider to carry out the recommendations and the ability of patients and systems of care to implement them.
Thank you. Any comments from the board members at this point regarding some final comments regarding the presentation of the recommended changes that we've been talking about? We'll sort of tie it all together here, okay?
Anything recommended here is more resources, which we've also seen adds cost. And it means that I think everybody here should make a commitment to try and make sure that that funding is made available. Because I think what we have to be concerned about is, for Medi-Cal, will there be coverage for this? And when we add more to it, will our children that have Medi-Cal get the care they need? So it's easier to say this is what we need to do. The hard part is going to go get those resources.
Okay. Any other comments?
Steve?
Yes.
If the board's going to take action on this today, I'd like to have a little bit more discussion about whether or not we should include a requirement that there be a separate anesthesiologist.
We will.
And so, okay, just want to make sure that we have that discussion.
We will.
That maybe we get a break before we have that discussion.
That's where you read my brain. As well as other parts of my anatomy. Hey, we're all alike, right?
Turn that TV.
Is that in the notes? No.
So, anybody else? Okay, we are going to take a quick, short cardiovascular stimulation break, as well as other needs. And we're going to come back in here in 10 minutes, okay? And we'll continue on with our discussion. So we have a 10-minute break.
Have a banana, 'cause that's